Hello.
Now I'm back. Of course, I started, and there was no audio. But it's very nice to see you. Good morning on this nice, quiet, perhaps ominously quiet, Saturday morning before the Karen Read retrial begins on Tuesday, April 1st. Welcome to those of you watching on X and the folks who just joined on the YouTube. Let me just pull up that YouTube and make sure everything is functioning. All right, very good. Sometimes the YouTube takes a second to get going, and I appreciate your patience. And then at the same time, we are going to review yesterday's Karen Read trial motion hearing to go over a little bit of the implications of the Rule 17 order for communications on Aidan TurtleBoy Kearney's phone between Aidan Kearney and Karen Read. And we're going to review some of the strange statements made by Kearney's counsel, Tim Bradle, about representations to the court about there being no communications between Read and Kearney on the phone. Yet in a motion we're going to read in 1 second, I can even pull it up on the screen, you saw it during the intro, there's already evidence from just a partial search and disclosure related to one of those phones that has confirmed communications between Read and Kearney. Not to mention the litany of other documents indicating direct communication between Kearney and Read during the relevant time period, April 1st through October 5th of 2023. Good morning, Deaf Otter. Very nice to see you. You'll forever be memorialized as an honorary towel for correctly predicting that it was Attorney Mata who was the one that was one of the 4 attorneys mentioned in that motion, and for that reason you have been welcomed among the fold of honorary washcloths and towels alike. Good morning, Kelly Patton. Good morning, Cookie Ramlaw. Always good to see you. Good morning, Grant. Was looking forward to hearing from you. Always looking forward to hearing from you all. I decided I was very tired yesterday. I went to bed at about 4 or 5 p.m. And I said, you know, I could do a stream and go over yesterday's hearing and the other relevant documents that I want to review, the ARCA disclosure motion from the state, and then Read's response. And then I want to talk a little bit about the retrial and my thoughts, new forensic evidence, the Lexus infotainment GPS data, Karen's potential return to Fairview Road at 5:23 a.m. on the morning of 1/29/2022 to confirm John was dead, John O'Keefe. A lot of stuff I want to talk about, but I figured if I had done a stream yesterday morning around this time, 5:36 a.m. on the East Coast, and I realized, so for a number of reasons, my sleep schedule is such that I am a lot more erudite, cognizant, and in the moment, in the morning. And although I can do the streams at night, I get a little bit frustrated, and I find myself wanting to get to the end of reading motions rather than actually focusing, or rulings, rather than actually focusing on the wording and the specific analysis. And I realize that that is not a good sign. It means I'm pushing myself beyond what I'm able to do. And so in that regard, I decided morning streams are a lot better. And I also reviewed yesterday's morning stream and found that a lot of people found it helpful. People are apparently up early in the morning. I know there's viewers from across Europe and other parts of the world, Australia, etc., who are, this is the middle of the day for them, or the afternoon. So in any event, morning streams are good for Towel, and I'm glad to be with you. We're going to review this hearing. I'm going to provide commentary, and then I'm going to also take a look at some of the strange statements, and then we're going to talk about why this hearing, what it really means in context, because Hank Brennan moved on the Read docket under Rule 17 for third-party records, even though it's not really a third party, because they're records held pursuant to a search of 2 of Aidan Kearney's phones in November of 2024, done via a valid court order, and Brennan won an order under Rule 17 for 3 specific categories of information from those phones related to Kearney's communications with Karen Read. Now, there were some intermediaries between Kearney and Read, Natalie, who's on the state's witness list in the Read trial, and then Karen's lawyers apparently as well. There's evidence in other documents which we'll review, specifically pages 29 through 31 of the search warrant affidavit for Karen Read's cell phones that was executed sometime in the winter, I want to say January or so of 2024. And in the context of those documents, there's confirmation that there were 198 calls between Karen Read and Aidan Kearney and 40 hours of discussion over the relevant time period. There were 28 contacts, respectively, 28 each, between Kearney and Alan Jackson, so 56 or so in total. And there are also a number of text messages, both through Natalie, the intermediary, and also direct communications from Karen to Aidan related to independent journalist Lindsay Gattani, in particular about Karen's relationship with the then U.S. Attorney Josh Levy in the fall of 2023. Then we'll also look a little bit about why in April, and this is on page 18 of Karen's Read search warrant affidavit from January of 2024. We'll look a little bit into why in April or May of 2023, when Aidan Kearney was first linked up with Karen Read and her lawyers, there was this weird colloquy where Karen was telling Aidan that he should talk over his problems with Alan Jackson and David Yannetti. Well, one of those problems, we're going to see some videos from an account that was like, Grant, I don't really like you, but you do good work or something. And I was like, I don't care if you like me. In fact, you can't authentically pursue truth if you're concerned about whether or not various parties involved like you, or you will find yourself compelled to compromise yourself in a situation. And compromise in a situation is one thing, but compromising yourself in a situation is a different matter entirely, and I won't do it. So I don't care if you like me or not in terms of whether your allies are being impacted by the truth that I'm trying to discover. I care whether the information I'm relaying is cogent and informed and enables and engenders public discourse to hold accountable various factions involved in this godforsaken circus. And so we're going to take a look at how there was a wiretapping investigation, potentially charges brewing unrelated to the Read case in April of 2023 for Kearney, related to a woman out of Rhode Island. And then we're going to talk a little bit about how I have very good information on this, and I know that the FBI, a field agent from the Worcester field office named Samuel Weiner, reached out to the Holden police and other parties in the orbit of that investigation right around April and May of 2023. And I really do think it's possible that Jackson and Yannetti pulled some strings, and over the summer of 2023, Aidan Kearney was indeed providing information to the federal government in the context of the now confirmed as closed federal probe into the death of John O'Keefe. And the reason why this is so multi-layered and complex is, and we'll talk about it, but there's a web of connections between Kearney and the DOJ, and a history of tension with the Norfolk DA. Firstly, Kearney's history of tension with history with the DOJ. Folks need to understand, the then U.S. Attorney in the fall of 2022, November in particular, when Karen Read walked into Josh Levy's office, was Rachel Rollins. Two things to know about Rachel Rollins. One, Rachel Rollins has a direct connection to TurtleBoy that predates the Karen Read trial and goes back to 2020 when a man named then representative on the federal level named Joe Kennedy Jr., I think he was out of the 4th District in Massachusetts, ran for Senate. Now, Joe Kennedy Jr. ran for a Senate seat that used to be held by a guy named JFK and currently is held by Ed Markey. Now, Ed Markey is an aging older senator, good progressive in my opinion, does good work. This story is neither here nor there about Ed Markey, but it is telling for the following reason. So there was a woman named Rayla Campbell who was a spoiler candidate in the Senate race. She was a Republican operative, and she would go to Joe Kennedy Jr. events and kind of try to sabotage them. Now, what's really interesting is Rachel Rollins, a very progressive liberal Democrat, very soft on crime, just notoriously progressive. You say what you want about that. I'm just describing it as it is talking directly to Aidan Kearney during that 2020 Senate race about sending Rayla Campbell to Joe Kennedy Jr. events. Mind you, Joe Kennedy Jr. is a Democrat, folks. So why is Rachel Rollins, a liberal Democrat, talking with Aidan Kearney about sending a Republican operative to a Senate race in 2020? The Democratic primary race for Senate. Well, think about it, folks. The Biden White House in 2020 had all the incentive in the world to make sure that Ed Markey won that Senate race. In particular, because if you know anything about the trajectory that JFK took on his path to the White House, the youngest ever elected American president, he went from, I think, the old tent 10th District in Massachusetts. His campaign headquarters, JFK's, were right down near Lake Street in the middle of Oak Square there in Lower Brighton. JFK went from there, the House of Reps, to the Senate, where he got foreign policy experience over a few years, and then immediately ran for president. Joe Kennedy Jr. would have been on a very similar trajectory to JFK. In fact, he would have been in JFK's old seat had he beaten Markey. And if you're the Biden White House, you're looking forward to 2024 because you still think Biden's going to run. You don't see this calamitous chaos coming with him failing at the debate and getting replaced by Harris. You're thinking you got to kneecap that ascent of Joe Kennedy Jr. He's going to primary Biden. And so what do you do to do that? You make sure Ed Markey wins that Senate race. Now, doesn't that explain, folks, why Rachel Rollins then might have been, as a thank you, appointed U.S. attorney just a few months later, or however long, a few years later? And then doesn't that also explain why Rachel Rollins, who got forced out of that position as U.S. attorney for launching a pretextual federal probe into now Suffolk District Attorney Kevin Hayden, because Hayden beat Rollins' ally Ricardo Arroyo in a primary for that seat, and as a result of Arroyo losing, Rollins got caught texting Arroyo saying hey, she would make Hayden pay, and then Rollins launched a pretextual federal probe into Hayden, recused herself, leaked the recusal letter to the Herald and the Globe, got caught, and then lied about it to the OIG, got alleged to have violated, in a formal OIG report, 18 U.S.C. 1001, and also got forced out of her position by May of 2023. So those are two elements to keep in mind. There's this pre-existing connection between Rollins and TurtleBoy, which may not have to bear directly on Karen walking into Josh Levy's office in November of 2022 with Alan Jackson and David Yannetti, but just keep it in mind. And then also you got the history in this office under Rollins of launching pretextual federal probes to target political enemies. And then you got to think about the bifurcated history of tension between Rachel Rollins and Michael Morrissey, and then also between Dustin Chow, the head of line prosecutors in what's called the Public Integrity section of the Boston DOJ, also having a history of tension with Morrissey. Rollins, because of itself a bifurcated issue, which is one, Rollins, when she initially came on as Suffolk DA, came to sort of fame or infamy, depending on your perspective, for being very soft on crime, like the antithesis of the broken window approach to prosecution. She wouldn't charge low-level offenses at all, and so Rollins was the Suffolk County DA. Some of the other DAs in the other counties really objected to this. They started critiquing Rollins for it. It caused some backlash from Rollins, who said the other DAs were impeding on her turf, outdated. I think she called Morrissey a meatball. That's one issue, one history of tension. The other issue was something that Rollins was eventually vindicated on, which was Rollins was one of the first DAs to say, I don't think we as DAs should be sentencing or seeking sentences of life for youthful offenders, even for murder, under age 21 or 25, because there's scientific studies that show that brains don't fully develop and that it's not really right to, much like a child, to hold a youthful offender in a life term with no possibility of parole under those circumstances. That was eventually vindicated by the SJC in 2024. That's now the standard. But back when Rollins initially brought it up when she was Suffolk County DA, it caused a lot of tension. And guess who was one of the 4 DAs that called out Rollins? I think he actually intervened in one of her cases trying to stop her from making this argument. Michael Morrissey. So does it not make sense then that when Karen Reed, David Yannetti, and Alan Jackson waltz into Josh Levy's office in November of 2022, there might have been all the motive in the world for Rollins to initiate a pretextual federal probe, and then Dustin Chow himself, his wife was actually passed over for a promotion in the Norfolk DA's office and left the office on bad terms in 2015 during it wasn't a joint prosecution, but the state police gave up original jurisdiction over a murder that took place in Sharon 25 years ago, and it was related to Whitey Bulger, Frank Salemi, and Stephen the Rifleman Fleming. Okay, Frank Cadillac Salemi and Stephen the Rifleman Fleming. During that case, which the U.S. Attorney's Office ended up prosecuting after the state police gave up jurisdiction, and they ended up working together on the case, the DOJ and the Norfolk DA. That case caused a lot of tension because Chow's wife gets passed over for promotion. After Chow's wife gets passed over for a promotion, Chow goes around reportedly saying that he's going to do anything he can to burn down the reputation of the Norfolk DA and destroy the office. Okay? So you got that simmering, and people in these positions have long memories. So you got that simmering, and then in 2022, this perfect storm of Karen Read with her nonsensical allegations about why she wasn't responsible for the death of John O'Keefe, even though in my opinion she 100% was, and the evidence confirms it and will confirm it. Again, more than just a 9-3 vote guilty on one of the counts, in my opinion, on the retrial. Karen goes in spinning this crazy tale. You got an office in the DOJ that's known for launching pretextual probes to smear political enemies, and then you got two high-ranking officials, Rollins and Chow, with a grudge specifically against Michael Morrissey. That's how the federal probe got off the ground in November of 2022. What we're going to talk about a little bit more in the context of what I was just saying, this strange situation in April or May of 2023 where Kearney's facing a wiretapping probe relating to a victim in Rhode Island that's being investigated by the Holden police, right? That probe, there was definitely direct intervention by the FBI in that wiretapping investigation, and then it just goes away. Okay? That's the background that we're going to end up talking about if you want to understand really what happened when Karen Read and Aidan Kearney first met, and why Karen told Aidan in documented text messages, which also go to my point about how there's a record of intermediaries and Read directly communicating with Kearney from April through October of 2023. Telling Kearney, oh, Aidan, you should discuss your problems with Alan. That's always a shot in the arm. Okay, that's what that was about. No, it's not. People are saying, well, I wish you would leave the politics out of it. It's not the politics. Part of what you have to understand about what initiated the communications between Aidan Kearney and Karen Read in the spring of 2023 was all of this background context. It had to do directly with Aidan's problems, with Karen talking to the FBI and the DOJ about the pretextual federal probe that we now know is closed, okay? It had to do with why Karen had some allies in the DOJ, why this whole situation created the perfect storm for someone like Aidan Kearney to be able to walk in and have the FBI, rely on him, quote unquote, as a weaponized tool, therein giving them incentive to suppress that wiretapping investigation. And we're going to get to that in a bit. But again, we're going to watch this hearing, but remember, every communication between Aidan Kearney and Karen Read is relevant to what Hank Brennan is trying to obtain going into next Tuesday. And if you're wondering what this Friday hearing was even about and why we had to have it on an emergency basis, it is because Brennan is trying, first of all, Kearney's on the state's witness list for the Read retrial. And second, Brennan is trying to utilize the material that he's obtaining via this Rule 17 order that he won last week, Brennan, as in furtherance of he has to motion to get a consciousness of guilt instruction. So he needs the material for the motion. Then he needs to present the material from Kearney's phone as evidence while Kearney's on the stand to get Kearney to authenticate it. So this all ties in. Every single part of it will be part of Brennan's argument. How Kearney and Read initially made contact, and we'll review that chart and some of the information about that as well. The nature of those contacts, how they evolved over the summer of 2023, perhaps even, although we won't get there because it happened later, why they broke down in December of 2023. Why Karen was saying Aidan is a risk in a leaked text message on April 4th, 2024, following Kearney being jailed and Kearney starting to leak information about Karen's connection to Josh Levy. This all ties in, as I drop my cigar. All of it ties in. But yes, let's watch the hearing. I'll comment on it as we go through it. But folks have been asking me over the past 24 hours, can you please give a little bit of context as to what even happened and what was going on at Friday's hearing? And that is the context. Even though we don't have everything and we don't know the full nature of the communications between Read and Kearney and Read and her lawyers or whatever, we have some hints by virtue of that Karen Read search warrant, which I've analyzed in depth on this stream before. And I'm tying that into the unspoken undercurrent of Friday's hearing, which is that what's really going to come out in the Karen Read retrial is not just that Karen Read was having Aidan Kearney act as a pit bull and torment witnesses and run Jen McCabe's plates, reportedly in Kearney's own words, and ask Jen McCabe questions at children's lacrosse games. It was that there was this way more broad political situation going on with the DOJ and Karen's connection to the DOJ, and Karen and Alan bringing Aidan into that fold. Now, that's not going to be spoken directly during the hearing, but keep in mind that's what the evidentiary record shows, in my opinion, up until now. Okay, so I'm seeing a lot of comments. Let's start the hearing, and then at a certain point, or at the end, I will take your comments. Maybe I'm sorry, I had my eyes closed while I was relaying all that information, because that's the only way I can see the documents without actually reading them. I have to pull them up in my head, so I'm sorry I wasn't actually looking at your comments. But yes, thank you so much for moderating, Deaf Otter. Good morning, Trevor McIntyre. Nice to see you. JI5 said, Grant, do the things you said were very damaging, still damaging after this hearing and subsequent order? Oh, yes. Yeah. So we're going to watch this. It's not, and Brennan, we'll talk about it at the end, but Hank Brennan, if you did watch yesterday as a slight preview, I think there's room to file a follow-up motion or something here, because there is no real attorney-client privilege between Aidan Kearney and Karen Read. Obviously, we also learned recently in a filing on the Kearney docket from March 20th that they're both under active criminal investigation and could yet be re-indicted. But I think we're going to find out that Brennan might have some issues, because I think what the judge was implying during this hearing with his critique of Brennan is that even if there's no privilege, and the judge didn't say this could be attorney work product. If Karen communicated via Natalie or other intermediaries with Aidan, that's not work product. But if Karen communicated with Yannetti and David and Alan Jackson with Kearney, that's not really work product. And maybe Jackson and Yannetti could argue that their communications with Kearney, although not privileged as attorney-client, were work product of what they were doing for Karen. That doctrine, the attorney work product doctrine, is enough to maybe make the judge think, oh, if this starts coming in, we've opened the door in the Read trial to all sorts of KNOTTY naughty issues. That's what I think the judge was thinking about there. All right, so let's begin. Let me bring this hearing up for you now, and let's go.
Judge, this is 22117 and 23313, Commonwealth versus Karen Read, and separately the Commonwealth versus Aidan Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please.
Sure.
I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
117 is the Read case, by the way. Standing in the foreground is Special Prosecutor Cosgrove. In the background is Special Prosecutor Hank Brennan. Cosgrove is assigned to the TurtleBoy case, Brennan the Read case. The reason why Cosgrove is here is that Brennan is motioning for records from search phones held in the context of a case Cosgrove is prosecuting. So technically the motion and order was served on Cosgrove, even though the records are in the possession of the prosecution that is overseen.
Okay, Mr. Clerk.
Judge,
call the case and identify the parties.
22117, the Commonwealth versus Karen Read. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aidan Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aidan Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Betterow for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Betterow.
And good morning, Judge. Attorney David Yannetti for Karen Read, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Read.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so. Okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will.
Okay, so let's pause for 1 second, because although most of the parties get it, what we do not get the benefit of is the judge saying, at least in that moment, what his order was actually about. So please give me 1 second while I go about my bringing this order up for you on the screen here. And let's see here. All right, where's judge's order? There's judge's order. So we get the order that's allowed in part, and then I want you to take specific notice of what is allowed, okay? Because that's really what's going to be discussed, the nature, the scope of what can be turned over by Cosgrove. And remember, Prosecutor Cosgrove already turned over some material on Wednesday of last week to Attorney Brennan, and that material was then impounded and put under seal by the judge in light of the hearing that was scheduled for Friday, which is what we're watching. So the question really at issue in the hearing is not whether or not Brennan's going to get what's on the phones, because we already know that's going over from Cosgrove. It's the scope of the material and whether intermediaries are including Yannetti and Jackson, are really covered under the scope of the order. So, but let's just read it. So accordingly, the motion is allowed in part, such that the court orders the Norfolk DA, specifically Special ADA Cosgrove, to produce from the two previously identified cell phones that were obtained through search warrants in connection with the two criminal cases currently proceeding against Mr. Kearney, see docket numbers referenced herein, any and all evidence of communications between the defendant and Mr. Kearney concerning, so between Ms. Reed and Mr. Kearney, any and all evidence of communications between the defendant and Mr. Kearney concerning: 1, communication between Mr. Kearney and any witness or family member involved in the case as to the murder of John O'Keefe, to include but not limited to the following people: pictures or videos depicting evidence or intimidation of a witness of any in the family or witness or family member involved in the case described above; data evidencing dissemination of data depicting evidence of intimidation of a witness or any family member or a witness involved in the case herein. Okay, so let's read that just so we understand. It has to do with any communications between Reed and Kearney, which is up for interpretation as to the nature of how because communications don't have to be direct. Communications related to those three categories, all right? Just keep that in mind while we're listening to Judge go through this, okay? And I think that will be helpful for all of our purposes and will make it so that we can follow along.
We'll hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney.
Okay, so let's think a little bit about this. I think that Judge this may actually need to be reviewed because I think Judge misunderstood. Brennan was relaying what Bradel said at a hearing, and Bradel's going to point this out when he remarks months ago. And yes, Bradel said they had a joint defense agreement, or whatever they called it, joint defense. I think it was agreement, even though or cooperation. But then when Karen Reed's attorneys, when Mark Betterow was, they were trying to add Betterow to her team, even though that bid failed, They stated there was no such agreement of any kind or cooperation. So I understand. And also, Judge is trying to say, well, Brennan, Attorney Brennan, you said that there weren't any communications between Yannetti and Kearney and Jackson and Kearney. Well, okay, Brennan hadn't looked at the extraction, and Brennan wasn't on the case when there was a search warrant for Karen Reed's cell phone in January of 2024. So how would Hank Brennan know that, although there is a very specific subsection of that search warrant that talks about the record of communications, it just says there were calls, 28 or I think calls respectively between Kearney and Jackson and Kearney and Yannetti, not text, that at least not in that motion. So why would Attorney Brennan have any reason to think that there were texts between Kearney and those two attorneys? And furthermore, why would Attorney Brennan have any reason to think that those communications, that if they did exist, were the result of Karen instructing her attorneys to say things to Aidan Kearney? And so, Judge, here, I don't think either Judge is misunderstanding the series of events or just wanted to be mean to Hank Brennan for some reason, which I don't, as if to imply that there was some noncompliance with the order or whatever. No, if anything, I think Judge may just not have known that in the Reed case, at least maybe Brennan corrects Judge at some point, I hope he does, but in the Reed case, the defense explicitly exclaimed this. So Brennan may have said, on my understanding of what Mr. Bradel said months ago, there might have been some privilege there. But then the whole situation, there's a change of circumstance when the Reed defense gets up in court during the Betero Pro Hoc Vice admission argument and says there was no such agreement. It completely changes the argument, and Judge is applying an analysis that's not current with the state of the facts. So that's why I'm saying I don't know exactly what's going to happen from here, but there's just a fundamental sort of misalignment, and it is convoluted, the timeline, but it's a misunderstanding of why Hank Brennan was telling Judge, based on Bradel's representation, that there may have been such privilege involved, and why Brennan was also saying, and as far as I know, there isn't any communications. But it was a multi-layered misunderstanding by the judge based on the timeline, and we see Judge do this a few times. He starts scolding Brennan later in the hearing for bringing up, or maybe Jackson. Judge cuts Brennan off, and then Yannetti says, Brennan was mentioning material that was disclosed after this order. No, Brennan was referencing material that was in an order from Special Prosecutor Cosgrove, or a motion from Special Prosecutor Cosgrove before the order was granted. It was in the motion seeking the order to compel the records under Rule 17. And so this judge was just looking, I don't know if he knew Bradel or if he knew Brennan or if there was some history, but there was just some going at Hank Brennan here that was based on a fundamental misconstruction of the evidentiary and factual record. And that's why even when I watched this the first time, I was like, I hope this gets corrected, but I was very busy yesterday, so I wasn't watching as closely as we're going to watch now. But it was just right off the bat, Judge, I don't think was getting what was going on. So let's see how it plays out.
And Ms. Reed, during the time frame in question with regard to these three articulated categories, be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that, one, there are in fact a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order...
So pause. The judge is acting incredulous, but if you listen to what I just said before the judge said that part of his statement, judge shouldn't be confused. The reason why Special Prosecutor Cosgrove, weeks after Brennan, or multiple, I think, days, not weeks, after Brennan made his initial statement to the prosecutor, to the judge, Special Prosecutor Cosgrove is saying to the judge, Kearney, Reed's attorneys already stood up in court and said there was no issue. Bradel wasn't right about that. There's no joint defense agreement. There's no privilege. And judges cherry picking, very specific, untextualized, and decontextualize parts of the record, and then using that to really be mad at Brennan and Cosgrove, when in reality it was Reed's own lawyers who caused the change in circumstance that resulted in what Judge is seeing as a problem for the prosecution. But what was in reality a natural evolution of the prosecution's argument in response to what Reed's attorneys were saying in court about the nature of this non-existent defense cooperation agreement, therefore no privilege. That's why I got frustrated at the judge.
Did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
I think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other?
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Okay. Well, we all agreed, counsel, that those, in fact, would be privileged communications without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Brado. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy of Mr. Kearney. And then Mr. Brado responded, well, it's a little more complicated because we know he was under investigation.
Okay, pause. So the reason why Judge Krupp is asked Brado at the time, but even there can't even if this cooperation agreement exists, which by the way Reed's attorney said it didn't, so this is not even a correct hypothetical. Going into the second layer of it, the communications in question are between April and October of 2023. There was no legal issue that Kearney was dealing with related to these matters in the Reed case between those periods of time. So Brennan might actually have to ask for a review of this because there was just a misunderstanding by the presiding judge yesterday, in my opinion, on a lot of very core issues relevant to the weight of whether the scope of the order, the question of whether the scope of the order covers the non-privileged communications between Kearney and Yannetti and Jackson. It's a serious question.
Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Brado answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege.
So what the fuck, Judge? You knew this? And so Judge is saying, Brendan, why your argument was that Bradel told you this, but then didn't you know Yannetti said something different? Yes, later on.
Between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date, but those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043, in that pleading, it is set out by the Commonwealth's pleading that there is, in fact, information.
Important to note here, because the judge is going to cut him off, in my opinion, completely wrongly. This is the document that was filed on the 20th. Okay, we'll bring it up and we'll look at it. The 20th of March, before the court's order issued. This was the motion, the public motion, regarding a matter in Kearney's case related to these phones. It was a motion. Judge issued his order, I'm pretty sure, that day, that afternoon. So that's why this is so frustrating. All Brendan was doing was referring to a document that was on the public court record that was filed the day of or before Judge issued his order as part of the pleadings.
Demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823 when they're asking for information, Mr. Kearney, so one of the attorneys. Attorney
Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible.
Hold on, pause. I think the judge got the citation wrong there. It's Bishop Fuller protocol. And it's from a case in regarding grand jury investigation from 2001, where the SJC outlined procedures to protect attorney-client privilege when privileged documents are at risk of disclosure, such as during a grand jury investigation or search warrant exclusion. The protocol aims to balance the government's need to investigate the fundamental protections afforded by attorney-client privilege. Here's the breakdown of how it works. First, so if this gets invoked, and this is what Brennan might have to actually deal with here. There's an identification of potentially privileged materials. There's a process established to identify them. It looks like a taint team or a filter team, which is already existing in Kearney's case, but only for his 4 other phones. Then there needs to be segregation of the material. If there's a dispute, that has to be brought before a judge. The court reviews the documents in camera to determine the status. We look at 1.6. And then the exceptions to 1.6 as to client confidentiality are narrowly construed. Then the judge decides which is privileged and thus protected from disclosure and what material can be released to the state. Then so it comes from a case called Commonwealth v. Bishop and in regard grand jury subpoena. So Bishop 93, Fuller 2001, which addressed how to handle these privileged materials. It's not a single codified statute, but a judicially developed practice used to safeguard attorney-client privilege. So yeah, that's what the judge was referring to. He got the site wrong, but that's what Brennan must be thinking about over the weekend. I think he wins under that protocol because it's not the privilege is Reed's, and there is no privilege. In fact, you break the privilege if you start communicating with third parties like Jackson and Yannetti were doing with TurtleBoy, and you're not doing it for the purpose of representation because there's no investigation of TurtleBoy at the time. At least, maybe outside of that Holden thing, but that they weren't legally advising him related to his communications with Reed throughout the summer and fall. All right, let's continue.
Purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that...
Wait a minute. Bradel, we already know, according to the established record, that Reed was using intermediaries. Yes, I get you're saying this to the judge, but upon review by anyone, this judge or otherwise, this is a weak argument because Brennan needs to address the intermediary question. And since he's calling Natalie, who was one of the intermediaries, of course Brennan should know this, and this is going to have to be addressed. I've said there might be reasons for delay. And remember, folks, just because we start jury selection doesn't mean that there's not evidentiary and motion issues ongoing during jury selection. This is one of those things that's, as I said, KNOTTY. If you actually reach the merits under Bishop Fuller, and mind you, I'm not a lawyer or your lawyer or anyone's lawyer, and this is not legal advice. I'm a towel. Get a lawyer if you have questions about the law. Get a towel if you're striving to locate on universal love and shine it as a beacon of hope in a world defined by despair. But, no, this is asking for this protocol to be invoked because the communications between Yannetti and Jackson and Kearney as a byproduct of an intermediary function for Reed, and we know in the motions Jackson and Yannetti are saying specific things like Karen and her family say this, or this is Karen wants this. It's enough to show the intermediary relationship. And then it brings up the question of whether there was one time where Kearney was saying he was going to bring a bullhorn to a court hearing and bring hundreds of people on the steps to rise up tempers. That's bordering on witness intimidation. And David Yannetti replies back love it. And it leads to this situation where Brennan could also think about the crime fraud exception to the attorney-client privilege rule, not just the disclosure of the third party to the disclosure to third party exception as to the relaying the communications in the form of an intermediary relationship between Reed and Kearney. All of this stuff comes into play. And then, as I mentioned, the work product doctrine, which is not really directly related to the privilege claim, but more of a subsidiary issue where maybe Jackson and Yannetti would claim, this communications with Kearney were work product as of our relationship to Karen Reed. But even then, it still requires analysis, and we haven't got there yet. So people were saying, this was a huge loss for Brennan. No, not at all. We haven't. This was opening the door. What judge literally just opened the door for further review of this issue in a way that could really imperil Reed, Jackson, and Yannetti, and forget the Kearney too. because what Judge is saying is, yes, Mr. Brennan, now I'm understanding, because I think Judge midway through was reading docket 53 and said, and then heard Bradel just say, so you're disclaiming any previous understanding by Mr. Brennan that there was a potential joint defense agreement, and now you're telling the court, like Mr. Brennan told the court, that no such agreement exists. And now Judge is saying, well, that means I need to think about if there's any privilege, how it applies, what's the scope of it, and the order that I issued, it didn't consider that. So therefore, Mr. Brennan, we need to relitigate this in essence, but for now I'm narrowing the scope of this order to exclude those communications and only include the communications between Kearney and Read. Now what's wild is Bradel's going to go on to say there's no communications between Kearney and Read related to this. That's ridiculous. There's already in docket 53 which Kearney's lawyer read because it was a response to his motion. There's a direct statement on page, I think it's 8, paragraph 2, saying that Kearney and Read, there's communications from Read to Kearney on that device in this context, specifically about documents related to Read's case, which is covered by the order because it was promulgated to Kearney in the context of his activities related to witnesses in the case. Okay, so Bradel saying that was ridiculous. Judge is not like just slapping Brennan and Cosgrove down here. That's people are totally misreading this. It's almost like Judge was in a bad mood. It has nothing to do with the what happened here. What happened here was just the order scope is what the order is as of now, okay, related to Read and Kearney's communications. And then the order, if it needs to be revisited in light of the change of circumstances and the development of this evidence that Kearney had direct communications with Jackson and Yannetti, potentially in the form of Jackson and Yannetti serving as intermediaries for Read, then we need to do a different evidentiary review, and then the order could potentially be expanded. That's what Judge was saying. I can't believe people misunderstood this so badly. Yes, Judge was not in a good mood for a number of reasons, and I don't really know exactly what's underlying this. It doesn't seem like this is the reason he's in a bad mood, because this is, any judge, in my opinion, in my lay opinion, would just say to this, okay, so like he said, I see now that Mr. Yannetti in his Betterow affidavit said something different than Mr. Bradel, and now, just like Judge said, we should do this Bishop Fuller review, Mr. Cosgrove and Mr. Brennan, and for now, Mr. Cosgrove, turn over by Monday the records that aren't going to be subject to that further review. Let Mr. Brennan review, do with those as he will, the communications between Kearney and Read. Judge has already seen them because the status report was filed last Wednesday, so Judge is going to know that all he's doing is Cosgrove is excising just a little bit of the material related to Kearney's communications with Yannetti and Jackson. Maybe it's a lot of material, and leaving for now Brennan to review the communications between Kearney and Read. Then, clearly, we're going to come back and we're going to review this issue because Brennan, it looks like he's going to have to file some kind of follow-up motion, and then either the motion to supplement the order or whatever, the supplement the Rule 17 production, because the scope of the order is going to necessarily have to be widened to take into consideration the newly discovered intermediary relationship by way of Yannetti and Jackson between Kearney and Read. Okay, so that's really what Judge is saying. This wasn't a loss. This was a reiteration of the existing order, a temporary narrowing in scope, at least as to the material already turned over, just for the purposes of revisiting, clearly soon, this issue of whether or not the communications between Jackson, Yannetti, and Kearney can also go to Brennan. That's all this was. I hope people were saying all sorts of things on different ways. I think they just people watching this just totally misunderstood Judge's distemper and anger at this situation, and it doesn't even seem like Judge was angry at this situation at bar right here during that we're watching. It seems like Judge was just not in a good mood and was just laying into people, and he was nicer to Bradel than he was to Cosgrove and Brennan. But on the whole, I don't think anybody really understood, or maybe some of the more nuanced commentators, but I don't think anyone understood what was actually happening here. All right, so that's what folks should understand. This is only one part of a series that we're going to now see develop of hearings related to this situation. No doubt, unless Brennan chooses to abandon this, but I think the evidence is of such strong weight. Brennan doesn't know what it is, but he's seen the public filing in docket 53 from docket number 53 in Kearney's case that details, in response to a motion from Kearney's lawyer, details from the state from Prosecutor Cosgrove the extent of some of these communications. So Brennan can read that. That's a public motion. And Brennan now, I think, really has to think about whether invoking this Bishop Fuller protocol to get the further communications, along with the communications he's already going to get between Kearney and Read, is worth his time. And, I'm leaning, I think I said it yesterday, I'm leaning yes. I don't see why he wouldn't, because although Judge started off upset, when Judge read that note from Yannetti in the Read case saying that there's no privilege and no defense agreement, and then Bradel reiterated it, that does call for a review in light of change of circumstance and further evidence produced by the Commonwealth in the Kearney case to Brennan. And remember, Brennan needs this because Kearney's going in the case in chief, and Brennan needs this material. So there's a compelling state interest and a short order timeline that's going to be called for here. And the judge, I think, sitting on the bench knows this, and that's what he's really forecasting here, that he's ready to look at this. Look at this again. All right, let's keep listening.
Only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Read.
I'll stop you right there, Attorney Bradel, because you raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Read that may also include members of her defense team. So it is my belief that is what might be at issue, but I will probe further of AD.
You know what's going to happen when Judge probes further or looks at this more? It's not just, forget group text, intermediary relationship. Judge wasn't even thinking about that yet, but that's going to come up.
Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Read regarding.
All right, pause, Mr. Bradel, Mr. Bradel. What are you doing, Mr. Bradel? Why must you torment me? Why must you torment me, Mr. Bradel? Mr. Bradel, what does this say? This is Special Prosecutor Cosgrove writing in the March 20th motion. Undersigned counsel has reviewed some of the data from one of the two cell phones lawfully searched pursuant to warrant prior to any defense request for a taint team. Its contents strengthen the Commonwealth's argument here. Kearney's phones contains text messages between not only the defendant, Kearney, and Karen Read, but Kearney and attorneys Yannetti and Jackson as well. The text exchanges also make clear that the Read team was in telephonic and email communication with the same people. The Read team repeatedly provided Kearney with information, including videos and copies of documents, sometimes with a request, always acceded to, that he not use it or not use it yet, lest the Commonwealth discern its source. At times, the Read team would suggest angles for Kearney to cover, this is what Brennan was reading, or otherwise ask for his assistance. For example, on 8/2023, and this is exactly, bro, he cut Brennan off before he got to say this. Read texted Kearney, do you have the memo town employees were emailed about speaking to you / reporters? Alan wants to blast it. Brennan got cut off right before he read that. That was what 8/8/2023. Brennan was about to read that, which is the key issue here, which is, and I don't know why Judge cut him off. Maybe he knew it was coming. It wasn't. Read texted Kearney directly. We have it. We have it right there. It's on the page, Mr. Bradel. And Judge should have let Brennan say this because that's material. It's material. And then you also see there's other stuff about Read's team responding to Kearney's specific request for information, discussing strategy, and quite frequently stroking his ego by accusing Kearney about his YouTube presentations. By the way, you want to see some of the things that Attorney Yannetti said to Mr. Kearney? Here are some representative examples from Attorney Yannetti. On April 22nd, 2023, he texts Kearney, "That was priceless, dude. Great fucking show. Really enjoying the turtle reporting." On 5/29/2023, Yannetti assured Kearney, "You are a class act. Karen and her parents thank you." Oh, direct intermediary communication. A few weeks later, on 6/9/23, Yannetti texted Kearney, "Another great article by TB. You are doing God's work." Told by Kearney on 6/9/2023 that on July 25th, Kearney will hold a protest on the courthouse steps where Kearney will have a megaphone this time and make sure hundreds of people are there, Yannetti responded that he loved it. On 8/18/23, by the way, people pointing out typos, the Read team filed a motion that misspelled ARCA yesterday, so get off your high horse. In response for Kearney's request for names of criminal defense attorneys who might want to appear on a YouTube discussion panel with him, Yannetti forwarded the names of 4 lawyers and their cell numbers and suggested how to approach them. And I think we found Bob Motta appeared a month or 2 after that request. And then also, by the way, because it comes a little bit later in this motion as another footnote, Kearney reciprocated by passing along information he had come across, his own theories, the names and contact information of certain potential witnesses. Both the Read team and Kearney took pains to conceal their actual relationship. For example, on May 3rd, 2023, Yannetti texted Kearney, "Dude, don't be offended if we don't shake your hand on the way into court. We want to maintain the separation and your independent investigation." And then they butt slap Kearney. Yannetti himself butt slaps Kearney like a few months later or a year later. By the way, let's read footnote 6, because what else is just nestled in here that didn't even come up at Friday's hearing? On March 27, 2024, Special ADA Kenneth Mello, on or about the final day of a grand jury sitting, asked the grand jurors present to return indictments against Kearney and Read for conspiracy to intimidate a witness. The requisite number of grand jurors did not vote to do so, and therefore the grand jury returned no bills. However, at the time of ADA Mello's presentation, he had not viewed, because they didn't get searched till November 2024, he had not viewed any of the data from Kearney's phones discussed, because the court order didn't come down till August of 2024 to search them, and it was not presented to the grand jury. And then, mind you, there's way more evidence from May of 2024, internal group chats that were leaked, Kearney's Facebook group chats where he's talking about Karen, instructing him to run Jen McCabe's plates and ask her questions. All of this was not available at the initial grand jury. So notice this. The Commonwealth's investigation into these matters remains open. That sentence basically says Karen Read and Aidan Kearney are under active criminal investigation. And the Commonwealth knows of no bar against presenting these allegations to another grand jury should it elect to do so. Basically saying they're both going to get indicted again if the Commonwealth wants. And there's really strong evidence. So I hope folks understand Bradel was not being forthcoming with the judge there. He was trying to be weaselly, but no, there's no argument for Mr. Bradel here. There's communications in that production between Read and Kearney. Bradel wants to run from it like a scolded dog, but they're there.
Witness intimidation. There are none. So that there should be exactly 0 documents or texts or emails that should be responsive here. Absolutely 0. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that, and we are anticipating a request that you will look.
Oh, pause. Okay, so I thought Brendan had been given the files under impoundment, and turns out we're not even there yet. The status report was ex parte, and the court hasn't authorized either Brennan or the Read defense to get them yet, or Bradel. So we're waiting for this status report to be disclosed pending a resubmission on Monday, which we'll hear shortly. But that's what's going on. So this is extraordinary in the lengths that Brennan is going, as he's going to say at the end of the hearing, to follow procedure, because Brennan's saying, "I don't even know what's in them, Your Honor." And Judge realized that midway through. He was like, "Oh, Mr. Brennan, that's why you said that, because you had no idea, rightfully so, that there could potentially be these intermediary or whatever communications. This introduces a change of circumstance." And eventually you can see Judge really backs off, calms down. He even started cutting Bradel off. And I think Judge then takes the full weight of what had happened and then realizes, okay, so what we really need here is to redo this, submit the production without the intermediary contacts, just Read and Kearney. I'll review them. I'll take into consideration Bradel's argument that the direct contacts between Read and Kearney might or might not be within the scope of the order. I don't think Bradel has a strong argument there. So that stuff comes in, and then next week or whatever it is, I think Brennan now has the invitation. In fact, I heard Judge say it, to revisit this issue under the Bishop Fuller Protocol regarding the expanded scope of records that Brennan did not know about but is now informed exist, although he doesn't know their content, outside of Docket 53, the public filing we just read. Outside of that, Brennan has no idea what is on this status report, okay? Brennan and the judge knows though, but Brennan's now saying to the judge, or the judge is saying to Brennan, listen, we need to revisit this. Okay, so it's a simple change of circumstance. I understand it wasn't that there was a confusion about judge's order. It's that this is a much more complex issue than would initially appear, and therefore we need to bifurcate it, hand over the records that are easy to deal with now, the Read Kearney communications, hand them over, I'll review them. Judge is going to do that Monday probably. And then separate and distinct from that, coming up on whatever it is next week, Brennan can ask for a review of this issue in light of the expanded material between Kearney, Yannetti, and Jackson. And there's a whole more, that protocol is not as simple as, and this is what Judge is really getting at. This is simple for now. Give over the communications between Kearney and Read, Judge reviews them, applies them to the order. If it's in scope, Brennan gets them. Okay, simple process. What's more complicated is the intermediary relationship or group chats with Jackson and Yannetti involved. That requires a Bishop Fuller privilege analysis, work product analysis. Okay, fine, do that separately. That's all Judge is saying. Judge eventually got there. He eventually got there, but at first that was completely unnecessary hostility because it really, I mean, Judge should have, maybe it's more complex than I think just because I follow it so closely, but Judge could have seen that right away. I mean, there was no reason to be aggressive with anyone. It was simply a bifurcation question where he could have got there in 5 minutes. Instead, there was a lot of yelling. Not yelling, but incredulity.
Look at that, to ask you to look at that in camera and see if that complies with your order. It can't, it doesn't, it cannot comply with the order. Your order said Kearney and Read, not third parties that may or may not have spoken to Read, and these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank
So
you,
the fact that
Attorney Breda. I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Read's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Read?
I think the actions of Ms. Read's attorneys on her behalf are the actions of Ms. Read. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney and between Mr. Jackson and Mr. Kearney and Ms. Read and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that they act together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Read and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting in ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Yep, and the judge isn't saying, by the way, that this is his permanent decision. He's saying, listen, we need to, for now, just limit it to that, and then we need to review this whole separate issue separately. And then Cosgrove, we'll see the end of it in a second, goes on to say, oh, yes, well, I can do that by Monday, and the court's pleased with that. But I want to take a look at something, because someone just raised a very, very interesting question. I'm going to get to all your comments in a second. I also want to say, God bless you to the person who just sent a donation. I'm so grateful. Just a lot going on in Little Towels Live, and I'm trying very hard, and I'm running around, and I'm going all sorts of places, but I'm going to make it through. And I haven't eaten yet today, but I will try to eat a little bit later. And if you do like this stream and want to support it, that means a lot to me. But you don't by any means need to send donations to ask questions. It's not, I don't do super chats or anything, or memberships. Maybe we'll get to a point where that's something I want to think about. But even then, even if you ask super chats or whatever, the questions that people ask are all treated equally. Your question is treated based on merit. And if I think it's a good question and not derogatory or discriminatory or comment, then I will read it. But yes, God bless you and thank you so much. I'm really eternally grateful. And sometimes I don't see the donations pop up, and I feel extremely guilty because I see them after the stream. And although I'll reply and say thank you, then it means more to me to be able to say thank you in real time. But what I do want to show folks here is, let's take a look at this. Someone raised a great question. What is David Yannetti saying on June 9th, 2023? What article did TurtleBoy write on June 9th, 2023, you might be asking? Then David Yannetti said, another great, what did he say? Another great article by TB, was that it? So let's see here, another great article by TB. What exactly was David Yannetti talking about? Did Towel manage to locate that? I think he did. By the way, disclaimer, I'm just presenting an article as it is written by TurtleBoy. I disclaim that ahead of time. I am simply presenting it. What did TurtleBoy write? Oh, it was about the attorneys themselves. Hold on one second here. Let me change the page around so we can actually see it. So this is what was written on June 9th, 2023. Great question, by the way. Thank you so much to the person who sent it in. It's actually over on Facebook. I don't stream there, but I shared the stream there, and someone asked the question. And it looks like this is the article. Oh, wow. And it turns out, and we can, I can bring this up as well, but that is the very thing that in May of 2024, in an internal group chat, Aidan Kearney implies that it was Karen Reed who asked Kearney to ask Jen McCabe questions and to run her license plates. And so it's Yannetti calling Kearney's article attacking Adam Lally another great article. Oh my God. Let's see if there's anything really offensive in the article. Oh, Alan Jackson and David Yannetti started making statements about what had previously been reported, even though Yannetti and Jackson were laundering material through Kearney so they can mention it in court motions and like create a cyclical loop. Oh my God. Let's see. Yeah, Jen McCabe Google searched at 6:23 and 6:24 a.m. A right-head artifact was misinterpreted by Richard Green from an unrelated search at 2:27 for Hockomock Sports. And then Green apologized in open court for misunderstanding deletion related to that right-ahead data, which was not user cause, but instead just a write-ahead in the cache for the way that functions. So Green misread a data point and caused all of that nonsense, and as a result of misreading that data point, Celebrite updated its GUI, and now write-aheads in the WallDB can't be misinterpreted. Oh my dear God, why would you put that fucking shit? What is wrong with you? Why would you put autopsy photos up like that? That is fucking horrible. What is wrong with you? Who would do something like that? I'm glad I skipped right over it. That's just outrageous. Let's see. So Alan Jackson never encourages anyone to contact Gemma Cave or witnesses. Oh, really? Well, who did do that? Turns out the ring camera footage was deleted, probably by Karen. What? Adam Lally was very prescient here. He saw exactly what they were up to. Read in the defense with Kearney. People just weren't listening to him. Oh, and Jackson was under the gun with his pro hoc vice status even back then. Oh, Adam Lally's going to come out the hero in all this. He saw this from the beginning. He was working so hard to try to tell people while staying within the line with the rules, because Lally had to speak only through court motions and oral argument. Wow. So Yannetti was signing off on attacks on Lally. I wonder if they screened this article. They're still calling Lally evil. Oh, dear God. All right. So that's very deeply concerning. But let me bring up something for you all now. That's not the post I wanted. First of all, let's bring up the search warrant affidavit for Karen Reed's phones, and let's just take a look. What page is it on here? Page 19, right? Yeah, let's look at that. Hold on. That's when they show Karen and Aidan starting to communicate. But let's show the specific enumeration of all the phone calls between Jackson and Yannetti and Kearney. There we go. Look at that. 19 of 31. Shows Kearney communicating directly with Jackson and Yannetti starting on April 22nd. This was known back in 2024. And then you see Natalie sending messages between Kearney and Karen. And then that's also, we're going to talk about this a little later, why this paragraph is very important regarding Kearney's wiretapping problem with the victim out of Rhode Island. And then here's the enumeration between, there is a certain point where it shows all the texts and calls between Karen, Yannetti, and Jackson. Let's see, where's it come up? Let's see. Oh yeah, and then it talks about Yannetti would like pretextually drop information in court, and then even though it was actually from the defense and leaked to Kearney, he'd be like, that was reported by Kearney, we didn't have anything to do with it. And then Yannetti even said that's something the defense team would have no knowledge, even though it was the defense team who gave it to Kearney. And then let's see, where is the list of communications? Let's see. Then they started communicating directly. So several text exchanges suggest Karen and Kearney communicated directly without an intermediary. Karen and Kearney were clearly emailing and using Signal. Oh, here we go. So there we go. It shows that 189 phone calls between Karen Reed and Aidan Kearney, 40 hours in duration. There was Signal app calls potentially. They increased greatly at the beginning and the end of June. The communication continued through the fall and winter, and they stopped talking on December 21st, 2023, right before Kearney, right after. So that was the day after Kearney got his charges were bound over by indictment. He was indicted on December 20th, 2023. That was literally the day after that happened. The October 2023 charges from Stoughton were bound over by a grand jury, and the next day Karen stopped communicating with him. It shows that Aidan talked with David Unetti and Alan Jackson. The David Unetti number 29 times. I thought it was 28. And then 9 times from April 9th to May 2nd. And then Jackson's number 29 times, 3 calls from April 20th to May 1st. So there you go, folks. I mean, oh, sorry, I didn't have this fully over. Hold on 1 second. There you go. You can see it right there up on your screen. I was able to locate the extent of the communications there and what we were talking about between Kearney and Jackson, and the communications with Read as well. There's a lot more there, folks. I'm telling you, we can see it here. And if you want to see, this document is the Karen Read search warrant affidavit. So there is a lot there. And I also want to bring up for you these leaked communications because I think these are incredibly important. So let me bring them up for you. Let's take a look at the group chats, shall we, from the spring of 2024, and let's see what Aidan Kearney was implying about what Karen Read might have told him. And how are we going to do that? Well, we're going to search. See, Twitter doesn't, or X doesn't like tags anymore, but the hashtag function for finding information is actually incredibly useful. So I don't see why they're so resistant to it. It's not like it's a weird GUI display, like it looks weird font wise, but no, there's no reason why it can't still be around. All right, so I did indeed find it. Let me pull up. Is this the first image that I want? Yep, so that's one of them. I'm going to pull that up for you on the screen now, and then we have some of the other ones as well. All right, great. All right, so let me just grab this. There we go. Okay, so let me zoom in a little bit for you here. Give me 1 second. Actually, you know what? I think it's even better if I just do this. What is that? What is that? A May 3rd, 2024 group chat between Clarence Woods Emerson, which is TurtleBoy's admitted alias on Facebook, and Jenna Rocco? What's that? And what is, read from top to bottom to top, what is Aidan saying? Aidan saying, ultimately, Karen is thinking about Karen, and I was thinking about her. I never told anyone who told me to run Jen McCabe's played. Oh, you made a typo? Wow, people make typos? Just like Jen McCabe in her Google search at 6:23 in the morning in the cold at Karen's request as to how long to die in cold. I never told, which you mocked her for no reason, Aidan, because that's just a terrible thing to do to someone who can't use their hands in the cold. A disease, by the way, that Jen and Karen both suffer from that causes that. Woods, TurtleBoy says, corrects himself, plates. So the sentence reads, I never told anyone who told me to run Jen McCabe's plates. Wow, I wonder who that was. But also, I think you might be, this is Jenna Rocco, but also I think you might be jumping the gun, and I don't want you to end up hurting your relationship with Karen by feeding into this in a negative way. I do know firsthand that Kelly Read and Nathan Read greatly appreciate what you've done for Karen, and I have a feeling you'll eventually be invited in. I'm not going to, but I have a right to express my disappointment. And then you want to read a little bit, you want to read some other chats here? Yes. So let me zoom in a little bit to the left here. We'll read them all, don't worry. But what's it say there at the bottom? Reading top, this is the same leaked group chat. So it's, by the way, we're after the No True Bill in March of 2024. This was May. What do these say? TurtleBoy, I was indicted for asking Jen McCabe, did you think you could outsmart Karen Read? Guess who told me to ask Jen that? Question mark, question mark. And now I'm not allowed at trial, but I kept my mouth shut. And look what he says above. And I took the charges and protected Karen and went to fucking jail for Karen. Oh my dear God. Brutal. Brutal. That's, look at that. That is an admission, folks. That is just brutal. This is what people are like, Grant, how do you see where all this is going? That's why. That's why, because these were leaked, and I saw them in the fall of 2024. Folks, look at what you're reading. And the context is this is an internal group chat about a Pro Karen Facebook page. But just look at that. It's not just there are communications between Kearney and Read. It's that Aidan told other people that Karen was telling him to do specific acts of intimidation. Run the plates. Ask Jen McCabe questions. And then we just saw Kearney's article where he was saying, oh, I wasn't doing any of that. And David Yanet's cheering him on. Meanwhile, clearly Karen was telling Aidan to do some of this stuff. People keep saying, Grant, why is this such an explosive bombshell? And yeah, I realize now it's because you have to actually track all the leaks over and you have to see it all. But yeah, it's there. And then what does Aidan say next, by the way? Look at this next message. Aidan says, the last time I spoke with Karen was Christmas Eve when Aidan admits to being a fugitive over that weekend. Admits to being a fugitive because his bail was revoked after he picked up new charges when he went over to Lindsay Gattani's apartment to try to inquire to her about all sorts of things like the grand jury, and then he got indicted for wiretapping her and witness intimidation due to what he did on the 23rd. Karen didn't say sorry, this is what Aidan's saying, or ask how she could help. Karen said she was pissed because now I, Aidan, am going to make Karen look bad and cause a distraction. Because Karen had warned me not to go over to Lindsay's. That's what he means by go over there. Meanwhile, Karen's the one who introduced me to Natalie, who is testifying against me, not Karen. Oh, how ironic. How ironic, because now Natalie's on the state's witness list for Karen's trial too. But look at what Aidan's saying there. Karen cut him off in December and last talked to him on Christmas Eve after the bolo with PC went out for his arrest and his bail got revoked a few days later. Karen cut him off. And I'll show you one more thing here, folks. I'll bring it up for you on the screen. I want to show you the text message, okay, that Karen Read sent about Aidan Kearney in March of 2024. And I want you to we get such a unique look into Karen's psyche by being able to bring this up. It's an exceptionally rare leak to see this kind of stuff. So you just saw those group chats, all this stuff. Yes, it's not being said in open court, but you have to realize it's the reality. So whether it's being said or not, there are people involved in this case who are definitely aware of these leaked documents, and they're leaked from within Aidan's own circles. It's not like the state had them. They were made public because of leaks from Aidan's own circles. But let's take a look here. What do you see here, folks? Oh, what do you see cut off? Let's pull it up. Let's make it wider, a little bit larger. Oh, is that Lindsay Gattani referenced? What's that? Is that a text from Karen Read herself in March of 2024? And Karen says, yeah, the Jay Roberts, that's Joe Warren, stuff is insane. He was at every hearing from the jump. I can't believe that's how she talks. Way too invested. I remember Joe asked Natalie, that's who's now testifying against Karen, to ask me to save him a seat, and I said I couldn't. Oh, wow, so Joe Warren and Karen Read had a falling out because Joe wanted to be in the courtroom with her and she wouldn't do it. And Joe asked through Natalie. Then Natalie asked me to ask my parents. Karen says, this isn't a pep rally. We are overwhelmed on hearing days and can't save random strangers a seat. Ooh, no wonder why Joe hates Karen. The courtroom is hostile as it is. I know Joe and Natalie were annoyed. It's so telling that Karen refers to Joe as Jay Roberts because Joe uses that name on Facebook. So this is telling that Karen, at least in March of 2024, was using Facebook a lot. She must be reading those groups a lot. There's evidence she leaves comments there, which is obvious. So But it's like people make fun of Joe Warren and like they'll leave fake donations on Karen's stuff, being I love you, Karen. My name's Joe Warren. If, that's way more damning. Oh, that was stronger tobacco than I expected. It's way more damning because what it says is that Joe Warren was a obsequious Karen Read fan and only switched sides because Karen didn't let him sit in court, and like, now we see Karen was saying that, I wouldn't exactly say Karen looked at him in a positive light. And then Karen even says, the courtroom is hostile as it is. I know Joe and Natalie were annoyed when I say no. What a weirdo Joe is. Oh, that's also brutal. I forgot about that part. So no wonder why. I mean, you can see now, like, Karen alienates people, her own supporters. She's her own worst enemy in some regards. But this is more pertinent to what I was just saying. Look what Karen says about Aidan. This was just a few days out after he got out of jail on February 26, 2024. And we can watch a clip of what Aidan and Karen's interaction on the February 26th, because it's so telling. After court, I have a clip of it. And that actually segues nicely into what I wanted to talk about next, which is some of my predictions for the Karen Read trial and what I think's going on. But I'm going to read your comments in a second. But look what Karen says. Aidan is a risk. I have been so careful to lay low, and he blows it all up. Last month, they took my phones, and I've had for 2 years. We just read the search warrant affidavit from that. So it was actually from February, maybe January. It had tons on it. And that's all from this Lindsay mess. So Karen literally blamed Aidan, blabbing to Lindsay about her connections to Levy, and Aidan's indiscretions and actions on the night of 12/23/2023, which resulted in more charges for Aidan on top of his other existing indictments. By the way, those charges from the Lindsay case, 2 of the 3 of them were bound over by a grand jury as well. So that's why Aidan's facing 18 charges across 2 tied dockets, 0313, and then the other ones I forget. Karen says, I can't expose myself to that anymore. Like, look, this is Karen Read's own words. How rare an insight is it into Karen's own psyche? Look, that's what you're seeing. That's why you watch these streams, because I'm a little towel. And I find all sorts of interesting information. And obviously this didn't come, the state couldn't have leaked this. They didn't have this. Karen doesn't talk with me. I'm just letting you all read it so you can see it, because I want to show you the clip from February 26th as well. That's going to take me a second to bring up here, but to just continue to reflect on the implications of that. Well, I pull you up a 42-second clip where, interestingly, I asked Karen way back in February of 2024 if she went back to Fairview Road before going to Jen McCabe's. So if I was asking her if she went to Fairview Road at 5:23 a.m. on January 29, 2022. And then we're going to talk about why no data from Karen's Lexus GPS infotainment system, or from the infotainment system that has GPS data, may very well confirm what Little Towel's intuition told him all those months ago. But we're also going to watch this video because it, at the very end, is the first interaction between Karen Read and Aidan Kearney after Aidan Kearney got out of jail on 2/23 or so. So on maybe a little bit later than that. So it might have been the day of, but 2/26 is the first time that Karen Read and Aidan Kearney see each other after Aidan got out of jail due to his actions on the night of 12/23/23, and then becoming a self-admitted fugitive from justice over that weekend. And you might say, Grant, what are we going to see in this clip? And then you're going to see a fascinating dynamic in hindsight. And all of history is told through the analytical explicative beauty that is hindsight. But in this particular circumstance, my word, it shows so much about everything that this case has become. And it says so much. There's so much unspoken context to human life. And when we look at things like this, I'll tell you folks, it brings a whole new perspective when you look at it in hindsight, because hindsight isn't just 20/20. Hindsight gives us much like me expanding this window in real time, the full picture. Wasn't that a good pun? The full picture. I thought that was really good. Ready to watch? Let's watch.
Karen, why'd you go back to Fairview before going to Jen McCabe's? Karen, why'd you hook Aidan Kearney up with the FBI? Well, that was Mr. Yannetti, wasn't it, Karen? Don't poke me.
Karen, keep going. Keep going.
Oh, she took a different way. Oh, my dear God, he fell. Richie, are you okay?
Okay, I don't want to watch him falling over the pole again. We'll watch the video to the end, but let's watch this part very closely. I think I can I slow it down? Can I slow the playback down? So what we'll do is we'll mute the audio, and then let's slow playback down to 0.25. How do I do that? Why can I not slow it down to 0.25? Speed, there we go. All right, now let's watch, okay? Ready, folks? Let's watch, because I'm a towel. Let's watch the slow motion heartbreak. It's like the Ralph Wiggum scene in The Simpsons where his heart breaks when Lisa turns him down. Let's just watch. The Karen Read, the creature. She moves slowly. She walks methodically, Alan Jackson to her right. He moves with a protective instinct with his hand. He guards his ward. Aidan Kearney sticks his tongue out, defeated, and goes about his day. Now we zoom to the left. Somebody tries to elbow or pokes towel. I avoid. We move slowly through the Dedham Sahara. Surrounded. The photographers waiting to capture their prey. Towel, make sure he doesn't fall over the stone wall. Attempting to keep Karen Read in the shot. Although Towel wishes he had panned to the left because right there we see Richie, microdots. Oh, that's not good. Richie hits the ground. Towel pans to the left, make sure Richie is okay. Richie seems to have dropped his phone but protected his expensive camera at the expense of his body. Stumbles a bit. That made me concerned for him. Seems to recoup. Towel pans back. We see Aidan Kearney trailing the pack. He is the black sheep in this moment. Slowly, the herd of Karen Read, with the dog in there, and her attorneys, methodically, with intent, searching for their car. Ted Daniel, perplexed. Towel then asks if Karen's going to take the plea. There was no buffer zone at this time. Karen hails her driver. Karen shoots Grant a look after he yells about the plea, and then looks down, and you can clearly see Karen being like, oh, God damn it, it's Towel. Alan Jackson smirks. Slow motion replays of this are very interesting. But I think, folks, if you're asking, Grant, why are we playing this? I think because this was February 26, 2024, it's this moment. It's this moment that just is so demonstrative of the relationship and the breakdown thereof between Aidan Kearney and Karen Read. Let's just watch. Oh, there's the arm. Oh, let's just pull her this way. Oh, no recognition. Oh, Aidan knew. It was at that moment. His hopes, his dreams, his future, his love for Karen Read, crushed in a moment. And that, folks, is the story here in so many ways. But there's something else I want to reflect, because you heard me ask in there, Karen, did you link Aidan Kearney up with the FBI? Let's take a little watch, if you would indulge me, in a video from... Oh, I don't want to go away from there. I want to go to the video shared just today. So let me do this. I want to go to the video shared from today at the top of my feed, actually, because it goes to what I was just talking about, which is the FBI connection. And someone asked, Oh, decent amount of you watching for a Saturday morning. It goes to the FBI connection, and someone actually played 2 videos that were relatively relevant, although they said they didn't like me, but that's fine. My job isn't for you to like me, it's to relay information. So let's watch this first video, and the person, Victoria Haskins, that's being discussed here, remember, this is 4/22/23, after Kearney is talking to Reed's lawyers based on all the evidence we just wrote. And let's listen to what Kearney has to say in these clips. Hold on one second. And thank you for sharing these. Even if you are, I imagine this person is like Kate Peters' friend or something, which is why they don't like me, but I don't really give a fuck. Like, my job isn't to protect Kate Peter, Brian Tully, Karen Reed, or anyone. My job is to find out, in my opinion, to figure out what happened using an asymptotic relationship with truth as a maxim, and reveal what I think is in the public interest in order to balance and check both defense and state behavior. So I don't have any allegiances to you or your friends. If you're just a supporter or a washcloth, then of course this message isn't to you. But if your request to me is, Grant, compromise yourself for my friends, then my answer is fuck yourself. And you're a piece of shit for asking.
Any name for that chick who's been calling you? No, we're pretty close. I believe her name is Victoria Haskins. And while I was calling, making all those calls, I was getting calls from a block number. I'm guessing that was her. Just Victoria Haskins, just understand this. We're going to get you. Victoria Haskins, for those of you unfamiliar, last Wednesday afternoon, she made a false 911 call to the Holden Police Department and said that I had a gun in my mouth. They sent armed police officers to my house under the assumption that I was carrying a gun around in front of my children, threatening to kill myself. That's illegal. We're going to get you, Victoria. Just understand that.
Well, that explains why Aidan had a hostile relationship with this woman. I guess it explains the wiretapping investigation because she was calling him. Let's see what Aidan says next. I think the implication here is he might have been texting David Yannetti
Click on
about
the
this situation.
thing above for Turtle Chat. We're going to get her.
Wow.
We're going to get her.
I wonder if Aidan was texting Yannetti about Victoria Haskins right there. You know, and it really does make me wonder if, like, Jackson and Yannetti were like, oh, just talk to the FBI about this, you know, and as long as you help them. And then the other thing I wanted to talk about earlier is the timeline here, folks. I think Aidan was only useful to the FBI over the summer of 2023. And once the Reed, John O'Keefe probe, the federal probe, went nowhere, I think it transitioned to a probe of Sandra Birchmore's the murder of Sandra Birchmore and the cover-up thereof by the very same unit, by the way, that was investigating the Reed case, the very same MSP unit. I think it turned to that in August of 2023, and then TurtleBoy became useless. And that's why, according to my sources, when Aidan Kearney over the weekend of December 23rd, 2023, tried to get Leah Ferreira's cell phone number, he couldn't get it. FBI agent Leah Ferreira, who's definitely, according to what I understand indirectly, very much involved with the public integrity unit and public corruption and these cases. In fact, Leah Ferreira's name is on the medical examiner sign-in sheet that Ted Daniel released pursuant to a records request showing that Leah Ferreira was investigating the Sandra Birchmore cover-up. So I think what happened was the Karen Reed case and all the attention paid to it was actually artificial. And I want to play you all a video right now to explain a little bit about what I think Alan Jackson, the FBI, and David Yannetti did. Now, the Reed case was not actually the primary investigation. I think it was way more investigation into the state police. And all the attention to the Reed case, all the artificial cover, TurtleBoy's role in it, was just a way to run a honeypot, to generate tips about the state police so that the federal government could find out what was really going on and actually pursue something, even though the federal government under Levy, Rollins, and Dustin Chow knew the O'Keefe probe was pretextual and baseless. They were using it as cover. That was the big secret. And this is literally like, you could argue this is state secrets or anything like that because it's an investigatory technique. And you might say, Grant, what the hell are you fucking talking about? There is no way that the FBI draws artificial attention to certain bloggers or journalists in order to draw tips. Okay, I really hope that you are committed to your answer on that. If your opinion in this moment is that is how things work, I'm about to blow your mind. And I'm going to do it in real time, and I'm going to sit here and then explicate to you how real this really is. So let's go ahead and type in a little name called Steve Miller, and let's bring up the wonderful clip from your little towel. So give me 1 second here. Now, actually, you know what? We're going to read the whole, let's watch the clip, and then we're going to read Tal's excellent post, because I actually did a full enumeration and explication of the meaning of this clip in the context of the retrial already. But let's watch the 3-minute clip. I think that will be helpful. I'll read the overview, and then I'll take your questions, and I'll read back some of the chat about what's actually going on, and we'll talk about why I think there's so much secrecy about the origination of the connection between Aidan Kearney, Karen Read, and her lawyers, because of the pretextual nature of the federal probe into John O'Keefe's death, and then the eventual opening of a probe into the cover-up of Sandra Birchmore's murder in the fall, which we know started, by the way. Josh Levy confirmed that the Birchmore federal probe started in August of 2023. How do I know this? Because when Matthew Farwell was indicted of August of 2024, Josh Levy said directly on camera in public at the press conference that the probe started 1 year earlier, August 2023. So think about that timing, folks. April, May 2023, TurtleBoy, Read's lawyers, federal connection, really ramps up the federal grand jury into the Read case over the summer of 2023. Ramping up even though it's pretextual. And then all of a sudden, Birchmore cover-up exposed, August of 2023. Feds lose interest in Read. Try to cover their tracks, obviously. That's the ARCA tie-in and whatnot, to cover the fact that the feds knowingly allowed Read and TurtleBoy to run an operation to attract attention for tips about the MSP. That's the root of the feds and Read and Kearney covering each other up. That's the root of it. Someone's going to find it, but I pieced it together enough to know that that's what's going on, in my opinion. It's national security, folks. So I don't know what you think. This might tip the scales in favor of disclosure by state actors like the prosecution or whatever. But Hank Brennan's really got to think about the implications of this. Now, yes, other journalists have talked about things like this in the past. I'm going to show you a video right now that really brings that up. Oh, look at that. But let's watch the clip. Let's listen. You hear it from the source. Don't trust me. Listen to the source, and then we'll read my explication in the context of the Read trial.
Was also playing offense, and he was playing for the FBI.
The feds came in and completely usurped the local police department investigation, which was going backwards, not even forwards. Nobody quite ever figured out what was going on, and now, of course, I can talk about both Buffalo and I were confidential informants for the FBI, and that started in 2002. And it lasted through 2007, the day the place was closed. And the confidentiality part is for 7 years, approximately.
So now you can talk about it. Well past that.
Absolutely. But for the 7 years that we were on contract with the FBI. So it wasn't a matter of just, I can't talk. I mean, I don't think I'd go to jail, but I could get in a lot of trouble. You're not allowed to talk.
Yeah. In 2003, the Crazy Horse 2 was raided by the FBI.
And so I was thrilled when I saw the feds step in. The police were told, butt out. When the feds had their raid, I was told about it because they wanted me to cover it and nobody else. I later found out what the real basis of the raid was. Can't believe this story either when I tell you, but I will. They were there for only one reason, was to plant electronics. It was supposedly on the premise of drugs and guns. That wasn't
That was all the cover.
That was the cover. Yeah, that was the cover. And they were there. They planted so much electronics in there. It's cutting edge. I mean, only the feds would have what they had. That place was wired for the next 5 years.
This was the beginning of the end for Rick Rizzolo and the Crazy Horse 2. Over the next few years, the FBI, with the help of Buffalo Jim and Steve, surveilled and investigated the Crazy Horse 2 and its associates.
So my dad was a credible source to them. Yeah. When my dad said something occurred, it actually occurred. Yeah. But my dad would send in information to them, and I was told that it was very helpful.
My column was completely vetted by the FBI on a weekly basis, and that I would see things there that I thought were kind of interesting. They had how many places, how many links were there to my personal email address throughout, 10 maybe in each column. I didn't put them there. And all of a sudden, on Google and Bing and all the various search engines, if you type in Crazy Horse 2, here comes my column on the top. The next column, the next column. I mean, I'm taking up pages. So I begun to ask around, and the guys laughed and they said, yeah, we took care of that for you. You're famous. Okay, so I said, what am I supposed to do? I'm getting all these emails, people got beat up, they got this and that. He says, okay, that's what we want you to do. That's why we put you in there. He says, if it sounds legit, you got to call me 24/7. And he says, and you give me the name of the person, give me a little scenario as to what they told you happened and their phone number. And we'll get right back to him. He says, you got to tell them they're going to get a call. A guy named Bobby, he's a federal agent. Well, 13 people in the next couple of years, that's as many as I was credited for, emailed me. And they were the federal witnesses.
Rick and the people who had interest in protecting the Crazy Horse 2 may not have known Jim was working directly with the FBI, but they did know that he was a threat.
Folks, I hope you understand the implications of that, and I'm going to read you my post now, okay? We'll zoom in on it. And I want you guys, before I read your comments and questions, I want to give you this background before we talk about it so that you have the full context of what I'm saying. This is not just me riffing about politics. This is, as you've now seen from the evidence, the background as to why Aidan Kearney and Karen Read, when they first got linked up, why Kearney kind of had this issue going on, you help me, I help you kind of thing. And maybe why the feds may have also thought Kearney's blog was the perfect way to redo their operation, just like out of the playbook with the Crazy Horse 2 and having Steve Miller and Buffalo Jim involved. Steve Miller was a journalist, and the Crazy Horse 2 was a mob-run strip club that was in the same same business complex as Buffalo Jim's wrestling school, which was loosely affiliated with the WWF and the Attitude Era, which is how I got interested in all this. I had no idea in that random documentary about Buffalo Jim that I was only watching because he was affiliated with the WWF, which I thought was cool, that I would find this random kernel of information about how the FBI runs these operations, but it ended up being directly on point because I'm sure a lot of you, while you were listening to that, started hearing eerie echoes of what might have happened in the summer of 2023 with TurtleBoy's coverage of the Karen Read case. Wink and a nod from the FBI, use it as cover to generate tips. That's exactly what the FBI did with Steve Miller's articles related to the Crazy Horse 2. You heard them saying it. Now, in that case, it was more prototypical operation. They were running the articles to get tips about the people running the Crazy Horse 2. Here, I think it was a little more convoluted. They were running the articles in TurtleBoy's blogs, or at least sanctioning it or being pleased with the tips being generated from it, not to get information about the Read case, but as cover to get information about that state police unit. Very sensitive thing when federal investigators are looking into state law enforcement, to get tips about the state police. Now, here's what ties into this. Aidan Kearney was sending the FBI to people. I know he was doing that, because there's a person involved in all of this, and we're not going to get into any details because it ties into the Birchmore probe and all sorts of things. But there's a person involved in this who is definitely called and visited by the FBI, definitely at Aidan Kearney's suggestion, in my opinion. And it doesn't have to do with the Read case at all. It has way more to do with Brian Tully and Yuri Buchanan visiting this person to ask questions. So it had more to do with the tactics of the state police than the Read case. And furthermore, there's something else important to remember here. There is an intelligence war going on here between the state and federal government. How do I know that? At least by proxy through the different people. Because there's no reason that anyone should feel confident wiretapping the fucking FBI. And I know that there was someone in the orbit of the state police, frankly, and I think this person knows who they are, who wiretapped the fucking FBI to intercept a fucking call between the unnamed person I'm talking about and the FBI in the context of this federal investigation. I really am telling you, folks, there's something really fucking serious that developed after the Sandra Birchmore probe began in August of 2023, and you had the state police using either this network, including people who are willing to wiretap the fucking FBI, which is crazy, just fucking crazy, in order to figure out what the federal government was doing. And that's why I think Brian Tully was asking a lot of questions in December of 2023, before Aidan Kearney did that stuff on December 23rd, about the nature of the federal probe, what it was looking into. I think the state police knew exactly what I'm saying now, which is the federal probe into O'Keefe was covering that they really were onto the Birchmore cover-up as early as August of 2023. And listen to me, folks, listen. There are really, indeed, deep connections between the Stoughton Police Department, where Matthew Farwell worked, and that fucking unit at the Norfolk State Police that investigated Sandra's murder. Furthermore, I want you to know that the Canton Police, in my opinion, hate the fucking Stoughton Police. The Canton Police, I think, actually have a lot of fucking integrity, and nobody, especially in the Read case, and I don't think there's any tension over that. The Canton Police hate the Stoughton Police over the Farwell situation. And I think the state police unit, who should rightfully hate the Stoughton Police over that ring of cops related to Farwell in the context of the Birchmore probe. If you think Birchmore's the only victim, you're out of your fucking mind. There's an active fucking federal probe into not only the cover-up of Birchmore's murder, but certainly whether that was a fucking ring of cops in fucking Stoughton. And where did some of those cops go on to work, you may start to wonder? Oh, I don't know. Norfolk State Police Unit? Maybe, perhaps. Oh, yes. Yes, that's certainly true in the case of at least one, maybe two people. And is that why Matthew Farwell was initially cleared, and was there really indeed collusion? And furthermore, did a former now deceased chief of the Canton Police call in the fucking FBI on this ring of collusion between the state cops and the Stoughton cops? I mean, he's now passed away, which is the only reason I'm even hinting or saying anything about that. But that would certainly make a lot of sense, would it not? You folks starting to see the implications here? It's not that folks had something to hide, not related to the John O'Keefe and Karen Read case, but all this noise brought attention to a unit that may well have intentionally covered up Sandra Birchmore's murder. And guess who would want to make sure that the narrative is very carefully deployed on, I don't know, Netflix or otherwise, about the inner workings of the fucking Read case and how it ties into the uncovering by the feds of Sandra Birchmore's murder? Brian Tully and everyone in his fucking orbit, everyone who talks to him directly, that PI firm, certain other people, there's a fucking motive. And it has nothing to do with the investigation of John O'Keefe's death or Karen Read being responsible, therefore. It has 100% to do with Birchmore. This fucking liability up everyone's you-know-what. And compound that with Lindsay Gattani's cell phone extraction being manipulated while in the possession of state police to remove messages from only Brian Tully to Lindsay and then only Kay Peter to Lindsay before a 15-year extraction, including very sensitive records in the possession of the state police that were extracted from Lindsay's phone, were then turned over unredacted, except for those two sets of deletions, while the phone extraction was in the custody of MSP, to Kearney. Right as the Read trial started, the first Read trial. Convenient distraction from Tully's friend, who might also be a witness in the Read trial. Convenient public distraction from the Read trial. Further evidence, not just with regards to how Birchmore, with the investigation of Birchmore's murder and the cover-up thereof went down, but also how the MSP maybe behaves towards witnesses and how people are leveraged. Have you ever asked yourself, why is Matthew Farwell charged with the murder of a cooperating witness when the federal statute language restricts that charge to only someone who's cooperating with a federal investigation or attempting to? Have you thought about that? I'm not reading your comments right now. I'm going to look at them in a second, but I'm saying all this because I want you all to hear unfiltered what I think actually happened here and why there's so much lurking under the surface and why there's so much tiptoeing around misconduct by all parties, the defense, the state, whatever. Everyone but Hank Brennan and Robert Cosgrove, basically, and Ken Mello. Everyone but those people. Somehow, and Adam Lally, everyone but those people somehow involved in this case. and Laura McLaughlin. She wasn't. Other than that, has done, in different contexts, very bad things. The only people who I don't think have done bad things are Trooper Garino, the Canton Police, and I can't list a whole list of people who haven't done things wrong, but it's a very narrow list of people, I think, who somehow were involved in this that didn't do bad things. And they're fighting against not just the misconduct, but the fact that there's these webs of conflict of interest on both sides where there's a lot of hush-hush about this case. Not because of what happened to John O'Keefe at Karen Reed's hands that morning, but because of all of the webs of external factors that I'm now enumerating for you. And if you think for 1 second that this is not going to play into the retrial, you're completely wrong. There's Aidan Kearney's on the witness list. All of this subtext is bubbling to the surface. It's already implicit in the search warrant. By the way, I want to show you one more thing, folks. I want to blow your mind a little bit here. Let's bring up Karen's search warrant, shall we? Because there's a specific part before we look at what I was just going to show you. Do you want to see a really interesting part of the search warrant? By the way, Jane in the search warrant is Lindsay Gattani, the person that Aidan Kearney was telling about the federal, Karen's blabbing about the federal, her links to Josh Levy and the federal probe. Do you want to see something really interesting? So we see the complete enumeration. By the way, let's read a little bit more about why people might have been so intent on silencing Lindsay Gattani. Gattani stated that she met Aidan Kearney in September 2023 after exchanging messages on Facebook Messenger. Gattani stated she would communicate with two of Kearney's Facebook profiles, Clarence Woods Emerson and Aidan Kearney. Gattani states that she then began communicating with Kearney using the phone number that's been seized. So Kearney and Jane met in person following a Commonwealth v. Reed hearing. After that meeting, they had a romantic relationship. In the beginning of their relationship, Kearney stated he was close with Karen Reed's family. He would later start to date Gattani, state to Gattani that he speaks with Karen Reed every day. Gattani showed me a screenshot that Kearney allegedly sent her showing multiple calls on a certain day that showed Karen Reed, signal audio in the call log. Kearney told Jane that there was an intermediary between Kearney and Reed, a woman by the name of Natalie. Kearney stated Natalie and Reed were angry with each other. Kearney stated to Jane that he had begun talking to Gattani, that he had begun talking to Reed directly. Gattani stated Kearney and Reed communicate using the Signal app because it is encrypted. Gattani states that she does not communicate with Kearney using the Signal app. So that goes to show Kearney wasn't just communicating with her on Signal. For Karen, that was a unique thing that he was basically doing with Karen and wouldn't talk with other people, even though he was relaying sensitive information to them using Signal. Jane stated Kearney, quote, Gattani stated Kearney runs everything by Karen, meaning all of the blog posts and social media content is approved by Reed prior to Kearney publishing. Wow, it must be about the case, but wow. Kearney described Reed as difficult, controlling, and someone who gets irritated with him. Gattani stated Kearney showed her material related to the investigation of the homicide of John O'Keefe, including the 911 call and cruiser footage before it was leaked on social media. On December 1st, 2023, Kearney posted a live YouTube video entitled Karen Reed Case Gen 1 McCabe 911 Tape Breakdown. The audio is in fact a voicemail recovered by investigators from John O'Keefe's phone that captures Jen McCabe calling 911 from a different phone, reporting finding O'Keefe unresponsive. I think what it means is someone was calling John's phone, they were leaving a voicemail, and at the time Jen was calling 911 on a different phone. O'Keefe's phone was recovered by first responders on 1/29/2022. It's reasonable to assume that only the Commonwealth and Reed's attorneys are in possession of the audio file. So that implies that Kearney got the audio file from Reed, and I wonder if Kearney did stupid things with the audio file, like trading it to people, and that's what led to the police going to the state police going to certain people's homes, and then in turn that's what led to the FBI following up with people who were visited by the state police. You see where I'm going? Gattani described one instance where Reed controlled what Kearney would publish. Kearney wanted to release the Canton police cruiser video footage he had obtained from Reed. Kearney asked Reed if he could publish the video on his TurtleBoy platform. Gattani stated Reed said no to the request. Kearney, oh, this is fucking explosive. Oh my God. Oh my God. Oh my God. Kearney was frustrated and contacted one of Reed's defense attorneys, Alan Jackson. Jackson approved the release of the video. Reed later found out about Kearney going to Jackson and was angry. And it was right around November 28, 2023, which is when Lindsay and Aidan were still talking. That's explosive. That's part of what the content of the conversations are going to be about. Oh my God. Oh my God. It wasn't just that Karen was controlling it. If Karen would exercise editorial control in a way Aidan didn't like, Aidan would go to her lawyers who would override her. Holy shit. Holy shit. Lindsay Gattani is central to all of this. I hope Hank Brennan realizes this. I don't think there's any option to appropriately contextualize the extent of the relationship between Aidan Kearney and Karen Reed, which, by the way, continued not only between April and June of 2023. June is when Natalie and Karen have the falling out, and then Karen and Aidan start talking directly. Not only, I think it was because Natalie called Karen late at night or something and it upset Karen. Not only did it continue after that, but the conversations continued after the scope of the current production to Brennan on Kearney's phone through October 5th. And the only person who has any insight, other than Aidan Kearney, who will be called as a witness, the only person who has any fucking insight into what Aidan Kearney and Karen Reed were talking about between October and December of 2023, perhaps the most crucial time of all of this, is Lindsay Gattani. I don't think even I put this all together because it's just a lot and a lot of timelines and information. And this is explosive. This material that's being discussed right here is outside the scope of the dates in Brennan's request under Rule 17, which means Lindsay Gattani and her phone. That's the only way to get any of this in. And this is the exact thing that is the evidence that Brennan needs. It's way more than just direct contacts. It's prima facie evidence of a controlling publisher relationship where Reed wasn't just asking Kearney to do things. She was checking what he was doing to make sure what he was publishing was in line with what she wanted him to accomplish. That means his actions were her actions. It is an inescapable conclusion, folks. There's no way out of it. There's no other way to understand this. This is everything. We're getting a preview by way of this search warrant, which, by the way, Hank Brennan, although it all predated him joining the case, if he ends up giving a soliloquy we'll listen to at the end of the hearing that we haven't finished, where he says, if there's stuff that shouldn't have been leaked in the Reed case, because that's his case, that is not going to happen. It will not be tolerated. This search warrant was originally uploaded on a flipbook kind of website. It's a weird sort of flipbook. Originally, that's where it came from. And it was quickly taken down. I have the original link somewhere because the investigatory value of uncovering who uploaded that document originally to that flipboard is incredibly valuable. That document gets uploaded, okay, to the flipboard and then quickly taken down, but it gets saved. This is not a public document, okay? This is a public document because someone uploaded it to that flipboard website. And you want to know something really fucking weird? So a document went up, which was on the public record. It was on the court docket, but it went up from Special Prosecutor Cosgrove, the one we read earlier, the opposition to a motion from Kearney that disclosed all that those bombshell contacts between Kearney's lawyer and Reed and Kearney and Reed and all of that on page 7 and 8. That was on that same Flipboard website. Now, yeah, that was a public motion, but inductively, if Hank Brennan's serious about not tolerating disclosures that are inappropriate, then I think there's someone, and it wasn't Lindsay Gattani, obviously. I think there's someone who got this search warrant that might be close to the state police in the Reed and Kearney cases that released it that shouldn't have. Now, mind you, it is incredibly valuable and explosive information. We are getting literally, no one can have this. No one has this insight. No one, I don't think, has put this all together. People are still wondering what's in the Kearney and Reed communications. Well, first of all, we're not only seeing what's in the Kearney Reed communications, we're finding out about stuff that I bet Hank Brennan hasn't even fully put together, because I don't know if he's seen this search warrant, as to what Kearney and Reed were talking about in the fall, after October, and before December. But here it is. It's right here. Now, I think there might be an intentional attempt to keep this from Hank Brennan because of how Tully, after the fact, handled the extraction, and I think that is itself a bombshell fucking situation. So I think Lindsay Catani's the third rail in some regard, but if Hank Brennan's fucking serious about his commitment to integrity and holding actors accountable, then it doesn't matter as to what Tully did after the fact or the underlying behavior of Tully's allies in this context. This is fucking valuable. Her testimony is incredibly fucking valuable. It is perhaps there's no other way to obtain it. It is the only way to give insight into the extent of the relationship between the Kearney and Reed that really draws crescendos and explains the apex of their ongoing collusion in the lead up to Kearney being indicted on December 20th and then going on the run and the fugitive status. You can't explain that. If you're going to call Kearney, you have to bring this in. There's no way not to. It is the only context that fully explicates the nature and dynamic of that relationship. And especially with Kearney going over Karen's head, like, think about what this means in terms of the evidentiary argument that Brennan's going to advance under consciousness of guilt. It quadruples, quintuples, whatever you want to say. It's weight. Oh dear God. I had read this the other day, but I wasn't fully appreciating, in light of the relevance now, the material relevance of communications between Kearney and Reed, what this document was really saying. Because what it's really saying is that the contents of Reed's and Kearney's communications went beyond discussions about material or leaks, which are bad enough. It was explicit instructions and editorial control, according to this. That is every element under Mahoney. Every element, every single element checked off under Mahoney's joint venture standard for introducing this kind of evidence in the context of a consciousness of guilt instruction against Karen. Catani stated different sources of financial benefit for Kearney and his partners. Catani stated Kearney is doing well with donations. Kearney had alluded to the fact that he did not pay for a Lexus SUV he recently acquired. Kearney made statements similar to, if my frugal mother ever found out, may she rest in peace, ever found out I paid for the Lexus, she would be mad. And, quote, even if I think that's a typo, even if I didn't pay for it, what's wrong with that? A check of RMV records revealed the Lexus was purchased in the end of June 2023. Further records revealed the vehicle was paid in full using a personal check. Now, what's weird is Kearney said he took a loan or something and published those documents like in public at one point, but this clearly indicates otherwise. Now, here's where the really interesting part starts. And the stuff you're really only going to see here, because most people won't touch this, because both sides of this case want to hush this up. But I will not allow innocent voices who became unwitting sort of pawns or ping pong balls in a intelligence community proxy war between the state police and the fucking federal government be silenced because it's inconvenient to the different fucking parties on each side. That's fucking outrageous. This is a justice system. We are fundamentally at the core of this system supposed to protect the voices of the most vulnerable. That's why we have an adjudicatory adversarial process. And when you have parties in that process who know that victims and witnesses don't fucking have standing or very many rights at all, fucking doing this kind of stuff, it just absolutely infuriates me. It infuriates me. It infuriates me. And only really Hank Brennan can right some of these wrongs, in the sense that just because in my opinion, Brian Tully did bad things with the cell phone extraction and whatever, and just because of what we're about to read, people want to just pretend Lindsay Catani doesn't exist. You want to make her a non-person? That's ridiculous. Mr. Brennan, where is the justice that you speak of so highly? Where is the integrity that you claim to undergird, that you claim undergirds your entire approach to this? If you don't know about this, okay, fine. If you do, what the fuck is going on, Mr. Brennan? Katani stated she was told by Kearney that Reed's attorneys were working with the U.S. Attorney's Office, specifically acting U.S. Attorney for the District of Massachusetts, Josh Levy. Kearney would talk a lot about the federal grand jury and Levy with Katani. Katani stated Karen Reed was interviewed by federal law enforcement. Katani also shared other comments Kearney learned from Reed that are corroborated by other information known to this affiant. Brian Tully wrote this affidavit. How much do you want to bet that redacted or withheld piece of information has to do with who the federal probe was looking into? And how much do you want to bet that the fact that the federal probe and who its scope may have related to in the fall of 2023, after the Birchmore probe started, would have been of interest to Mr. Tully? Especially if Mr. Tully were, say, unprompted, asking questions about the scope of the federal probe. I don't even know if the DOJ realizes this. No, oh, by the way, you want to see what happened after Lindsay got served a subpoena for a future grand jury? Now, folks, by the way, if Aidan Kearney got indicted, right, on December 20th, 2022, and then Lindsay got a subpoena for a future grand jury after that grand jury indicted, do you think Aidan might have been freaking out because he would have realized that there was another grand jury that might have then proceeded to look into him and Karen? And in fact, doesn't the fact that there was a no true bill on March 27, 2024, which is just 3 months after all this is going down in December of 2023, 3 to 4 months, doesn't that seem to indicate that Katani's summons that she got for a very real grand jury I think she eventually went to testify in front of, which has been attested to in public court documents, doesn't it mean that that grand jury was indeed about Karen and Aidan? But Aidan wouldn't have known the scope, right? All he would have heard was Lindsay Katani, who has all this information about his fucking contacts with Karen, gets a subpoena 2 days after Kearney gets indicted, so it's got to be a new grand jury. Katani was served a summons to appear before the grand jury on December 22nd, 2023. Kearney learned Katani was served with a summons, and they agreed to meet at her apartment on the night of December 23rd. During this meeting, Kearney told Katani to tell the grand jury she did not remember anything, delete evidence from her phone, and told her he would hire an attorney if she cooperated with him. Kearney later assaulted Jane, although those charges were no pros and the grand jury didn't indict, but the allegation in the police report was that Kearney pushed Katani onto a couch because Kearney had written notes about what Katani had been talking about with Kate Peter on a notepad. And there was Lindsay's notepad, and Lindsay took it. Kearney set it down at one point, and then Lindsay took it and put it in her shirt. And Katani tried to take it back. She wouldn't let him, and he pushed her down, was the allegation. Now, that didn't get bound over by the grand jury, but 2 other charges from that night related to Katani wiretapping Lindsay, where he recorded her without her consent. An original version of the file exists. That file got sent around allegedly, and then there was a second version edited into the record, which will be very easy to prove due to reconstructive audio analysis that can be done on the file as to splicing and source audio. It's a very rudimentary editing job that won't survive deep audio analysis and deep forensic scrutiny. There was a second edited copy of the video introduced where Katani saying or consenting to the recording was apparently edited in a way where a part where Kearney inserted himself saying something like, I'm recording, in a part where Katani was saying okay to something else. But that's a matter for the evidentiary analysis pursuant to forensic examination during trial. The more relevant point is that this document is explaining how during that interaction it was aggressive, which led to Medfield police charging Kearney with A and B on family household member and witness intimidation. And then the wiretapping charge also comes later, and it's the wiretapping in WI from that night that get bound over by the grand jury. And remember clearly, if the grand jury is bounding over that charge on WI, they're seeing that record you just heard of about what Kearney actually went over and said to Lindsay that night in the context of their interaction. And then Kearney was arraigned on those charges on December 26th, and that's when his bail was revoked. And if you can see here, there is evidence, according to the search warrant affidavit, which was granted, of Karen engaging in witness intimidation and conspiracy. And I hope folks understand the relevance of what I'm pointing out here, which is there's a lot more coming regarding Karen Read and Aidan Kearney's contacts. I've shown you it. This is not me speculating. This is me enumerating with specific references to the factual record and primary source documents, a full comprehensive explication and theory as to what's going on with Aidan Kearney and Karen Read. But there's one more thing I want to do for you because I'm a towel. And that is, I want to read this. So, good afternoon and happy Monday, towel friends. When did I write this, by the way? I'm a towel. I wrote this on September 2nd, 2024. So I've been on to this for a while. Hold on, let me
Was also
so it doesn't play. Good afternoon and happy Monday, towel friends. I did some research and found this interesting clip about Steve Miller, a Las Vegas journalist and former FBI informant in the early 2000s, that has interesting implications as to the Sandra Birchmore case and the Karen Read trial, but not in the way that you might think. In the video, Miller explains how the FBI brought on Miller and his friend Buffalo Jim to do confidential human intelligence work. But for our purposes, Miller explains how he, as an independent journalist, was leveraged by the FBI for the purposes of furthering an investigation. 1, the FBI would screen each article Miller wrote about Buffalo Jim's case, involving a corrupt establishment in Vegas that was targeting Jim, edit those articles for search engine optimization purposes, and edit the articles to include strategic links to Miller's email. But the FBI would ensure, via SEO, that every search online related to the corrupt establishment would lead to links from Miller. Miller was told by the FBI that the FBI made him famous for the purposes of collecting information about the case. Sound familiar? The FBI would tell Miller that any reasonable tips that came into Miller's email should be forwarded by Miller personally to the FBI 24 hours a day. Miller was also instructed to inform those sources that they would be contacted by an FBI agent in short order. 13 of the tips that came in via Miller's stories led to federal witnesses testifying in the case being investigated by the FBI. Sadly, Buffalo Jim was also eventually murdered, and I think it's pretty clear why, sadly. In turn, and based on my post below about the fall 2023 evolution of the federal probe into the Karen Read and John O'Keefe case into an inquiry into the cover-up of Sandra Birchmore's murder, I have these questions. 1, did Karen Read and her lawyers link Aidan TurtleBoy Kearney up with the FBI in the spring of 2023 for purposes of obtaining information about corruption with the MSP in the same way that Miller was deployed in Las Vegas? And in turn, did Kearney get some degree of protection from the federal government? And let's think about that wiretapping case even more now in the light of that question. 2, did the federal probe of Karen Read and John O'Keefe's death confirm over the summer of 2023 that Read, while drunk, hit John O'Keefe with her car and then left John to die in the snow on a frozen lawn? 3, as a result, in the fall of 2023, did that federal probe then transition into an investigation of the MSP's role in the Birchmore murder? Brian Tully and John Fanning were both involved with the Read case along with the Birchmore case. And people can say Tully wasn't involved in the documents, but Tully absolutely was the supervisor of that unit, and all of the meetings that happened with the ME and afterwards tie in that whole unit. Was Aidan Kearney made aware of this development at some point at the end of 2023? But was he also told to continue doing his work related to the MSP, such as to keep collecting tips for the FBI to follow as to the Birchmore case? Did both Aidan Kearney and Karen Read have an incentive to keep this development from the public, to keep up the donation drives being run by Read and Kearney, and so Kearney would have cover to continue getting inside information from the MSP about his sources? Is this why, by the spring of 2024, Kearney was referring his sources to the FBI to speak about an ongoing federal civil rights probe of Brian Tully? Was a lot of the attention of the Karen Read case in turn just artificial online astroturf designed to provide cover for the actual federal probe going on related to the MSP unit assigned to the Norfolk DA, that being the cover-up of Sandra Birchmore's murder? Nice, neat package. An unfortunate, a sad, a regrettable, a lamentable package, but one presented in erudite, cogent towel style, somber though it may be. All right, I'm going to actually look at your comments now. I needed to do that. I'm sorry. I know you all left a lot of comments. I know I was not being my normal towel self and reading the comments as I was going. It was important to me that you heard my raw and filtered perspective on that. It involves matters that, for better or for worse, are close to my heart, and I feel it's incredibly important that I be able to relay the information to you in a way that is a reflection of what I have found to be the case, what I have questions about, and my own experiences. No one will deny me those experiences. They are my lived experiences. These are my lived opinions, and I rely heavily on the factual record for a reason, because not only am I trying to provide you insight and conclusions coupled with first-person experiences and a read of the primary source documents, but I'm also trying to stay authentic to myself and not compromise myself in a situation that presents pitfalls at every single turn because of the various conflicts of interest that permeate through both sides of this horrific nightmare. All right, so I'm going to scroll back now. I owe you all I owe you all reading through these comments, because I make a promise that if you make comments on this stream or ask questions and they are not discriminatory or derogatory, then I will read them. Trevor McIntyre says, people should also know Robert Cosgrove is a retired Superior Court judge, not someone who isn't familiar with all aspects of criminal procedure. Absolutely, he's very good. Yes. If you want to support Grant, very thorough coverage of the Read case. Oh, Def Otter, you're so kind. Def Otter left my Cash App in the comments. The Cash App is # GrantSmithEllis, and the Venmo is @GrantE1. Oh, I'm so, God bless you, Def Otter. And I haven't checked my phone over that last 20-minute soliloquy, but I did see some donations come in, and I'm just, not only am I touched, I'm overwhelmed. And you all, I was like, oh, I didn't even eat this morning, and I was getting worried about going into next week. I just have to get through the first or the third, and you won't see the donations open up anymore. But until then, I really rely on you all, and it means so much to me. I was getting frustrated listening yesterday, Kelly Patton says, because the judge would cut off Brennan as he was trying to explain. Yes, I think I tried to do my best to explain why that judge was unnecessarily pernicious in the beginning, or pugnacious, and then calmed down once he realized, after reading Jackson's supplemental affidavit to Bettero's Pro Hoc Vice admission application, what was actually going on. Let's see. That's a good idea. Trevor McIntyre says, Cosgrove can just file a bill of, I need that water bottle. Cosgrove can just file a bill of particulars on the docket with every text that was going to be turned over. I agree. Trevor McIntyre says, judge in the Read case that was from the hearing yesterday was premising his ruling that there is a privilege when there isn't. Agree. Maybe work product, but not privilege. JI5 asks, why does the judge keep cutting Brennan off when he's trying to make his valid legal arguments and submissions? A little bit of tension there for no reason. But that's what happens when you get, that's a bench, that's an angry bench. I was a little stunned by the judge's hostility towards Brennan yesterday. Very frustrating. Yeah, uncalled for in my opinion too. No, I'm not saying that gratuitously. I'm saying in light of the full weight of the circumstances we've now analyzed, the judge did not need to be hostile with Hank Brennan for any reason. Kelly Patton says, I was so frustrated, so I could only imagine how Hank felt. This man is trying to bring the truth to light, and I feel like they shut him down completely. Yeah, cutting Brennan off right before he read the material part about Karen and Aidan communicating, which is in the production, was a little frustrating. Anna says, I have no doubt Hank Brennan has a very thick skin, even with dealing with a judge who's in the wrong and not allowing him to speak. Judge seemed to cool off and came to his senses by the end. Agreed. Kelly Patton says, the Karen Read supporters thought this was great news, which I find comical. Yeah, opposite of great news. It's opening the door to Brennan to get a lot more information just pursuant to a ancillary process, concurrent process, compared to the messages between Aidan and Karen, which I think we've seen from an enumeration of the primary source evidence is going to be damaging enough as it is. The bonus of the Yannetti and Jackson conversations potentially coming in light of that complex analysis that the judge enumerated pursuant to those cases from 93 and 2001 as to attorney-client privilege material and work product doctrine, that is just a bonus for Brennan. Not a good day for Karen Read at all. Yeah, no, he wasn't shutting him down permanently on this issue. The judge actually explicitly said at one point there, Bishop Fuller, I think he said, there might have been a confusion of names, but it's Bishop from 93, Fuller from 2001, although the 2001 case is actually called In Regards a Grand Jury Investigation. But those two protocols combined together to provide what the judge, it actually gives us a hint as to, the judge didn't say it, but it was an invitation for Brennan to re-examine the issue under a concurrent ancillary process unrelated to the disclosures of conversations between Read and Kearney. Kelly Patton says, I have to give Hank Brennan a ton of credit for how he handles everything. I would be going across the table in the judge's podium. No, that is not what you do. When in a moment like that, it's not even appealable error. You have to realize that the judge is using a firm tone, but giving you what you want. He's giving you all the messages between Karen and Kearney. And then he's saying, oh, and if you want more, come back under the Bishop Fuller protocol. Those texts by Aidan Yannetti to Aidan Kearney. Isn't he basically encouraging Aidan's torments of these witnesses outside of the Karen and Aidan cases? Are there possible repercussions for Yannetti? I mean, the state definitely implies at one point in their brief that that there was criminal conduct and the source giving information to Kearney could potentially engage in criminal conduct. I don't know if they meant Yannetti or Karen, but yeah, it's there. The argument to make the case is there. During the first trial, Lally just seemed defeated to me. I completely get it. I pray over Hank's strength because the lies and BS never end. I think Adam Lally just had other cases. He was just the ADA in Stoughton when that case was arraigned, so this man took on a Herculean task. And yeah, he knew the case better than anyone else, but without encyclopedic knowledge of the DOJ and the federal government and all of that, there's no way in a million years you're ever going to be able to interpret that kind of thing. Let's see. So I'm scrolling through the comments here. I like to, as promised, read as many as I can. All right, so we're getting through the end of the hearing. Justice for Officer John O'Keefe says JI5, badge number 2490. I agree. Oh, good morning, Murder by Maestro. It's always so nice to see you, my friend. I'm glad you've joined us. Good morning, Maui Swift. Nice to see you as well. Maui Swift, honorary washcloth or towel. There's no hierarchies here. Washcloths and towels are both wonderful. Why haven't they charged Read with witness intimidation? I think they basically, in the prosecutors, has said that there's an open investigation and they could do so at any time. I think a parallel witness intimidation indictment to the trial, it's a lot to juggle, but we're moving there. But really, you make the consciousness of guilt evidence under guilt argument against Karen. You get to show the same evidence, and it occurs way quicker than a criminal proceeding. You could still do an ancillary or after-the-fact criminal proceeding for WI, of course. Nothing would stop you. But it does make me wonder if that's leverage. Prosecutorial discretion offers prosecutors the ability to not charge certain things for a deal. So, Karen, we won't indict you on WI. You want to wheel and deal? Or more indirectly, Karen will give you immunity on the WI if you testify against Aidan, and then we'll give you a 4 to 6 year sentence cap on manslaughter in the John O'Keefe case if you plea. So plea allocute in the O'Keefe case, we'll give you a 4, maybe 5 year sentence cap. We'll do it on manslaughter. You can get your license back. We'll give you immunity on the WI, but it's subject to a continuing cooperation agreement, and it's limited in scope, and you must testify in Aidan Kearney's trial. Then they've already indicted Aidan on witness intimidation and conspiracy and picketing and all of the other charges, and they just use Karen as a witness in Aidan's trial. Karen will be in jail, but it won't matter. She'll cooperate, and then as a result of her cooperation while she's in jail, she'll get the benefit of the sentence she negotiated. If she fails to cooperate or tries to not answer questions, she loses, and the part of the agreement, I'm sure, would be that the sentence would be revisited if her continuing cooperation is not sufficient to the prosecutor's liking. That's one way this can happen. The other way it could happen is Aidan Kearney's on the state's witness list. So you can simply say to Aidan Kearney, okay, we're about to indict Karen Read. If you agree to, 1, cooperate with your testimony, they can call Aidan either way and have him testify against Karen. But if you cooperate with us during Karen's trial as to the consciousness of guilt instruction, and if you agree to cooperate during the criminal prosecution into Karen Read, if we were to indict her for witness intimidation, if you testify at the grand jury, which would explain why maybe they're holding the indictment, if you testify at Karen's trial, we'll give you a blanket immunity on the WI, we'll plea you out on all the other charges, everything will go away. But it only goes away if you complete your obligations, which is testify at Karen's trial in a cooperative manner pursuant to the consciousness of guilt instruction by way of joint venture and WI with Karen. And then also, if we indict Karen Read, you must testify at the grand jury, and if she is criminally charged for that, you must testify at her state trial for witness intimidation. That kind of thing, absolutely. And remember, part of that package would be Kearney can't invoke the Fifth Amendment during his testimony at any point in time, if that is how the play happens. So that's really where I think this is all leading up to here, folks. That's why there's no indictment of Read or Kearney. It's within prosecutorial discretion to leverage either or both of them against each other for cooperation agreements, a grant of limited immunity, and then testimony against the other one. And then whoever doesn't cooperate, they're the ones who get screwed. And Karen, I mean, if you think about it, Aidan's facing a lot more strain. Well, Karen on the second-degree murder potentially, but Aidan is facing a lot of jail time under his 18 existing felonies. Plus, I think he picked up a new one in Stoughton District Court. He has more incentive to plea than Karen, but Karen has, although it would cost her more, she has the ability to secure a really good deal that would otherwise not be available to her. So they both have a motive to cooperate, but they're, what they would get in exchange for that cooperation is slightly imbalanced. Aidan stands to gain a lot more, but then again, Karen also could benefit from something like a 4-year deal in the context of manslaughter for John O'Keefe's death. Yes, it would require allocution. Karen would pay a heavy price and be humiliated. Her support would be decimated, but we're already heading that way. And people who love Karen, whether she admits it was an accident or whatever she does, they're still going to love her. She's still going to have support. They're going to write her in jail. They're going to know her afterwards. She will have a community around her for life. She knows that. So I don't think that's necessarily factoring into her considerations. Aidan, I think it's about self-preservation for him. So he has way more of a motive to cooperate, but I think the public hit to his reputation would be worse. I think he would struggle with that more than Karen would, and so I think that's weighing against him doing it. 60-40 for me right now. I think Karen's more likely to cooperate against Aidan, but for Aidan, it could be a fait accompli. It might not really be a choice at this point because he's going to be put up on that stand, and Brennan can force a grant of immunity on him, a limited grant of immunity, and then ask Kearney questions, and Kearney can't take the Fifth Amendment. So I think that's where we're at there. That's why. So did we figure out, Anna asked if we figured out who the 4 law troopers are. I've seen some good guesses, but no full picture. And clearly there's a Michigan connection if Bob Mata was one of them. So lawyer you know might be one of them. Perhaps Melanie Little. That's what Murder by Maestro guessed. Good job. JI5 says number 1 is Bob Mata, right? That's what we think. Of course, Karen blames someone else. It's the way she handles all things in life, anyone and everyone but Karen. That's what Kelly said. Anna says, I don't know. Lawyer, you know, still had something of a moral compass in 2023, but they very well could have contacted him. Well, remember, 4 names were suggested. Only one person did the interview that we could find with Kearney. Let's see, a bunch of other names suggested. This is superb footage. Yes, my slow motion footage. Anna says, Jackson putting his arm around Karen is basically saying stay away from him. Yep. Love watching your videos, are very good. Thanks, Carolyn Phillips. So glad to have you here. Folks, by the way, someone was saying earlier, you can like the video and subscribe from within the YouTube stream. There's a lot of folks who watch over on X, but if you'd like to leave comments, if you want to engage, get your questions answered, YouTube's actually a lot better for that. The comments stay on the screen so I can read them when I'm watching on the back end. And then also the YouTube stream has the benefit of from within the stream. If you click the like button or subscribe while watching the video, it apparently really helps the video and the algorithm and the channel grows. And that means a lot to me too. And it doesn't cost you anything. But that said, I also want to, someone reminded me because I just looked at my phone, a few of you sent some very kind donations and I don't want to forget to say thank you for that. It means a lot to me, even though I can't look down at every second and I don't want to miss them. So I'm just saying thank you. Grant got it spot on. I do my best. And did we all see that interview article where Yannetti said Aidan hassled one of his clients 6 years ago? Yep, that was in Yannetti's statements about his BC law presentation that he gave. He said that Aidan Kearney tormented one of his clients and things along those lines. The Sunken Grave says, I'm a soap dispenser. I welcome soap dispensers. You can be anything you want to be here. Murder by someone sent something in and they said, God bless you, Grant. Oh, God bless you. I'm a towel. I'm a very grateful towel. I'm a touched towel. I'm an anthropomorphic towel who experiences love in an overwhelming way that he doesn't quite understand. Like I said, if you gave me a $2 pink steering wheel cover 10 years from now, I would remember it and think of it as very touching. Much like the house elf from Harry Potter. Couldn't find the documentary about this that Grant recommended. Murder by Maestro. I just showed it to you up on the screen. Hold on. I'll give you the channel, my friend. I will not be deterred. Let's see. The channel that you want, Mr. Maestro, is... Hold, please. Wait for it. Are you ready for this, Murder by Maestro? The answer is go to Eric Allen, ERIC Allen on YouTube. He has 300K or so subscribers. The documentary you're looking for is called The Horrors of the Crazy Horse Strip Club, The Case of Buffalo Jim, true crime documentary. There you go. I'm a towel. All right, 1 second. Let me go back to our questions. Dewdrop says, good afternoon. Hello from the UK. Well, hello. I spent some time in the UK. I studied in Bath for a little bit, at Oxford for a little bit, although that was only a small segment of my larger program. UNIV is a very wonderful college, and I learned a lot about the distinction between town and gown and why the walls of the college are very high. Aidan only got involved because he heard there was probing and what? Murder by Maestro. That it's not derogatory, I guess, but it's a little bit profane. Dewdrops and others laugh. Good morning, all, says Amber Am. Great to see you live as soon as I wake up. Great to see you, Amber Am. Welcome. Always a pleasure to have you. Let's see. We're almost at the caught up. Oh, no, there's a lot of comments. Thanks for rewatching from the beginning, Dewdrops. You'll get caught up on what was going on with the hearing. Everyone seems surprised with recent hearing, but I did predict that happening in this chat. Yeah, it wasn't really surprising. What was interesting to me was the invitation for Brennan to get more material. Amber Am says she's really they really hope Hank is getting a new grand jury to charge KR with witness tampering and more charges. From your lips to God's ear. Dewdrops, do you remember? I said that we all know what those comms mean, but they are not direct comms between Karen and Aidan. Yeah, but that might not save them from coming in. Murder by Maestro. Murder by Maestro says, Grant, you are more central to all this than Lindsay. Nope, not at all. You don't understand. I got involved in this case, I would say the summer of 2023, although I was watching really back to the spring of that year, because Brian Riccio, who has now passed away, God rest his soul, a reporter from up in Revere, was covering this case. And Brian Riccio got burned by this weird Mike Crawford young jellyfish guy. And so Mike Crawford used to take advantage of people who would volunteer for him, and then when they would try to go off on their own to do their own projects, he would just like try to burn them as a form of control, in my opinion. And so Riccio was one of those people that happened to, a few other people that I know, and I was one of those people too. So now obviously say what you will about that situation, but the way it manifested itself was Riccio was covering this case a lot, and I had known Riccio, and he, I saw on his feed Aidan yelling at the witnesses and all that and whatnot over the summer, and I didn't really understand it, because I don't know if you've ever if you all have ever heard this story. This is not the first time that TurtleBoy had come across my reporting. I report on the cannabis industry mostly. I help implement and codify regulatory frameworks, 935 CMR 500.000 and 001 as an example. I helped work on the Chapter 180 of the Acts of 2022, Social Equity Loan Fund, Dedicated Levy, reform of the HCA process in light of what Correa did down in Fall River and the other manipulation of the local permitting process for cannabis licenses. In that context, I was covering this festival owner up in Maine named Jason Moodley, and Aidan actually covered some of my coverage of him, not in a hostile way towards me. Aidan was more covering this Moodley guy. But needless to say, so Aidan had covered my reporting before, but I didn't know much about TurtleBoy. I just knew of TurtleBoy as someone who did like FOIAs or something like that, and I thought he was a little abrasive in his investigatory style, but I didn't actually, because he would write blogs about like ratchet people and stuff like that, but then he'd also like write blogs like bragging about getting January 6th rioters like arrested. And I was kind of interested in this weird, like, figuring out more about the network that existed between, like, Boston Free Speech, Resist Marxism, some of these January 6th defendants, and then this NSC 131 group that I thought was kind of recruiting from within those other groups. And so I'm kind of like wondering, like, why is Aidan so interested in protecting national security by getting people adjacent to these like weird splinter cell, like all deep right-wing groups arrested? Like, why Aidan, the Republican, why does he care about this? But Aidan was also covering this cannabis stuff, the cannabis owner, so I knew kind of him, and he would like call people ratchets. I never really understood the purpose of like that, like finding single like mothers who are suffering and like trying to get help and being like, oh, that's a ratchet. Like, what the fuck? What the fuck? Like, what kind of internet nerd you got to be like, someone needs like a bed for their kid. That sucks for them. Like, fuck you. What the fuck's wrong with you? But anyway, so when I first saw Kearney yelling at these witnesses, the Riccios coverage, I was like, that is very perplexing to me. So I started looking into it. I didn't really, if you look back at my initial thoughts, I was like, listen, the Karen Read case is very complicated. And the way I first learned about it was just this friend I used to have, actually, not mutual friends with anyone. He was a guy in the cannabis arena. I was sitting on his back porch one time, and he's just telling me, like, oh, you got to look into this Karen Read case, you know, like, and he was trying to explain to me the timeline of Karen's movements between 12:31 and 5:35 or 6 a.m. on the morning of 1/29/2022. And I remember saying to myself, this is the most convoluted explanation. I can't understand what this guy's fucking saying. I can't visualize what he's fucking talking about. I have no idea who these people are. I don't know what the fucking car he's talking about is, what the town he's talking about is, the route, the houses, the street names. I was so fucking furious. And I was like, I got this vibe that he was presenting it to me in a way that was like not the full context or trying to manipulate me into a conclusion. And I was like, I was kind of, letting him talk. But meanwhile, I'm like, you know what? Just to spite this fucker, I am going to figure out what the fuck happened in those hours. And that's how it all started. And you can watch back in my original comments on this case, and you'll see me saying things like, so I'm looking into the TurtleBoy stuff. I'm intrigued, or I'm very concerned by how he's doing this to witnesses. That's my primary focus right now, piecing together who are all these fucking people? Why is TurtleBoy doing this to them? What is the larger context? What is happening here? Then, and you hear me say at the beginning, I don't know enough about the Read case to perform an opinion. And then you start hearing me saying things like, okay, I'm learning more. I'm leaning towards I think she is guilty, but I'm still taking in information. And then as I crescendo as I initially start covering the case more and more, then you start seeing me saying things like, I think she's very guilty. I think Aidan's very guilty. But that comes as I'm learning more and more and more about the case. So when you say I'm more central to this than Lindsay, no. Absolutely not. You have to think about the wider context of me, Little Towel, having no idea what the fuck was going on at first when trying to figure out what this case was about, and having to, from a distance, without knowing any of these people, reconstruct what the fuck was happening in both the context of Karen and John's case, which is very, 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 very complex. One of the most complex I've ever seen in my life. And then also the Aidan Kearney cases and situation. Lindsay, on the other hand, completely independent from me, doing her own thing, getting information, writing, covering things. Lindsay's just in it. These people are the people. She's living it. And these are two corollary concurrent tracks, and they don't cross, Lindsay and I, until like way down the line in spring of 2024 or something. Kate Peters, probably worst mistake of her life, was introducing us. Fuck you, Kate. I could send that day when Kate brought me over there. I still remember Kate had to leave or something, and she didn't say it, but as she was walking out of the room, I could sense the vibe in her. She was like, "Oh no, I shouldn't have done this." And I was like, "Yeah, motherfucker, you fucked up." But yeah, Lindsay just doing her own thing. She is. Whether or not there's an intentional effort to suppress Lindsay Gattani or otherwise by these various factions, you all must understand the brilliance of that woman, the resilience of that woman, how central she is to this story. And by God, if Hank Brennan can put it all together, she's going to end up being a central component of this, whether or not people want to cover up their horrific misdeeds on both sides of this case in the context of how that poor woman was tormented. She's an honorary towel, too. She's probably the only person I actually think of as an equal. Amber Am says, love Grant. Oh, thank you. I think I remember. It's just so frustrating. Oh, so we're reading other comments now. How much of this can come in through Natalie? Only through June of 2023, Murder by Maestro, when Natalie and Karen stopped talking. Natalie and Karen used to talk about houseplants. What is Natalie going to testify to? All of the contacts between Karen and Aidan between April and June of 2023 that Natalie served as an intermediary for. Natalie's not a lawyer, so she can be called. It's all good. Brennan will get it, just not through his previous motion argument. Yeah, he'll probably follow up. Let's see. Grant, you do awesome research. Thank you, Soil Nina. I try my best to present a full, contextualized, primary source referenced overview of the situation. There's a lot of history. And I remember it all too. I just have all these documents there, memory, like I have them stored in this like index in my brain. And so sometimes I can just like pull them out and like read the document in my head. And so I'm not like when I'm pulling them up for you, what's really happening is not only am I reading the document first from my memory, but then I'm like, oh yes, I think I archived this document in a post that started with the words like, dear towel friends, or, referenced X, Y, or Z, or use this hashtag. And then I go to X and then I search in the exact phrase that I said in the post that as the source I want to reference. And that's how I get to it. I mean, it's all categorized up in my head. I don't need like a reference or anything, but I'm so glad that you all appreciate it because I think I don't really think about this as research. It's more like a puzzle. So, but yeah, I suppose it does involve research. Dewdrop says, love Grant getting all this insight. Only found his channel the other day. Yeah, speaking of that, I'm so glad you found this channel. If you appreciate the content, you can give a like. You can subscribe from while watching. Apparently that really helps the channel. I'm still learning about this whole YouTube thing. So many of you watch on X because that's where I write most of my content, post most of my content, do most of my streaming. But ever since I started the YouTube channel, you all seem to really like engaging. You ask questions. You have great discussions in the comments. And that just makes me such a happy little towel that now, even though it's a little bit cumbersome to do 2 streams at once, I want to keep coming back here. I feel this is very pleasant. We have a great time. Someone said they love Julie Grant. I agree. Busty D said they have Aidan's bank records. I agree. Amber, hope so, fingers crossed. Julie Grant is great. I agree. 3, 2, 1 until next grand jury, says Julia. That's probably true. Good morning, Frank. Nice to see you, sir. Let's see. I'm obviously a little behind in the call. Oh my goodness, you are all just having a great morning. Let's see. New grand jury coming for Aidan and Kearney. Probably, I agree. Question, does Aidan Kearney have a journalist license? I understand that a person can get a permit. No, you don't have to show a legal license. You file under SJC Rule 119 Part B. There are some standards, but it's the Supreme Judicial Court. It's a court rule. It's not a license. You can't really license journalists because, and actually, let's read Bob Cosgrove's excellent explanation in response to your question, Soil Nina, as to why you can't license journalists. Bob Cosgrove actually spells it out so well that I feel it would be a disservice to not actually read it. Okay, so let's actually read this because this man was so kind to write this out. And we're going to read it. All right, ready? For purposes of the present motion, the Commonwealth does not dispute that Kearney is a reporter. Judicial creation of a reporter's privilege, however, would present practical and conceptual difficulties of a high order. Sooner or later, it would be necessary to define those categories of newsmen who qualified for the privilege, a questionable procedure in light of the traditional doctrine that liberty of the press is the right of the lonely pamphleteer who uses a carbon paper mimeograph just as much as the large metropolitan publisher or towel who uses the latest photo composition methods. Hey, I'm using a photo composition method right now. You're living a photo composition method. I'm inside one. This is wonderful. Freedom of the press is a fundamental personal right which is not confined to newspapers and periodicals, but comprehends every sort of publication and towel, which affords a vehicle of information and opinion. See, you can write things on a towel, wave it outside, and that makes you a journalist. I'm hilarious. Moments of levity, folks. Moments of levity. All right, let's see what other comments. Rest in peace, John O'Keefe. Yes, absolutely. Drop says, love how Grant explains everything. Thank you. I do my best. Glad I could answer your question, Soil Nina. Let's see. He was let me be frank with you, says, Judge was kind of instructing Brennan to file for more. I agree with you. All right. Let's see. Yeah, so, I mean, people are talking about other channels. Just do your research, folks. There are a lot of people who are conflicted in the orbit of this case. It tends to be either they, are very close to, some witnesses on the prosecution side or the state side. Just know who you're listening to. If someone's, never criticizing, Aidan or Kate, either way, or never criticizing Karen or the state police, you can tell a lot about you can reconstruct more from listening to what someone's not saying than what they are saying. Okay, just keep that in mind. Let's see. Yeah, there's apparently something called hybristophilia, maybe good memory. I don't know. Maybe that's what Let Me Be Frank's talking about. Let's see. Hi, Grant. Why isn't your channel showing up in searches? It's almost impossible to find. I don't know. It's at GrantSmithEllis. Maybe it's because the channel itself is just my name, so Google doesn't, or YouTube doesn't process it. Maybe it has to do with the channel growing. Maybe as the channel grows, the search results think it's more relevant. I don't know. We'll figure it out. If, from a month from now, you're still having trouble finding it in the YouTube search under GrantSmithEllis, which I think is the @ it's youtube.com/@GrantSmithEllis. We'll figure it out. We'll look into it. It could be a just how the string, the variable is written in the back end. Maybe I put the @ symbol where it shouldn't have been. Maybe it doesn't need an @ symbol. Whatever. We'll figure it out. Let's see. Good morning, says Dixie Doodles. This sounds like a good one. I must rewatch later. Oh yes, I was having quite a towel morning. It's been a lot of fun. Let Me Be Frank says, Grant, Bob Motter injects himself in these cases, so it's not new that he did this with Delphi, Idaho, etc. Sorry, Frank, I don't know a lot about Delphi, Idaho, those cases. Maybe he did. I trust your judgment, but I'll have to look more into the record. Mott also used to work with active defense teams. Well, sounds like he's a lawyer. Oh, EMBS says, you are a national treasure. Can I support you via PayPal? If so, how? You're so kind, EMBS. I don't put my PayPal up. Actually, you know what? Maybe there is a way to actually put my PayPal up. Hold on. I'm not. Some of you, I think, hear me saying that I don't have money for food or things like that, and so it's important to you. And I don't want to make it so you can't help, especially when I need it. And obviously there are long periods of time during the month where I don't ask for any help because I don't need it. But if you are going to ask, let me see if I can find a way to find my PayPal Me link, which I think does exist. I mean, I'm pretty sure it exists. All right, so to do it, what you need to do is, let's see if I have a username on PayPal. So it seems like you can go to paypal.com. Hold on. paypal.me//GrantEllis. Okay, so I'm going to go right into the description here, because that was really a very kind thing of you to ask. You didn't have to do that. But we actually do have a PayPal link now, and it's paypal.me/GrantEllis. All one word, GRANT Ellis. And if you go to paypal.me/GrantEllis, it says you should be able to send a donation that way. I had no idea we could do that. That shows you how functionally inept I am when it comes to helping support my own existence and feed my brain calories to do these live streams, not to mention all the costs that I incurred to do the software and all of that. I didn't even know you could do a paypal.me link, but there you go. It's in the description. God bless you for asking. Whoever just asked that actually fueled me to fix a problem I've been having. So EMBS, I am so grateful to you. You are so kind. EMBS says, lawyer you know is not a good person in their opinion. Have you seen how he treats the way more knowledgeable father when he goes on his show? I don't know the context of that, but I will try to learn more about it. Let's see. Someone says they really enjoy Frank's show, which I agree. Frank does very good interviews. We've interviewed before. Let's see. Someone says, Frank says, bravo, Grant. Thanks very much. I'm glad I could help with you. I'm glad I could help your morning be better. Let's see. Keep talking on YouTube, Grant. Sure, let me reflect. I'll keep doing it. I enjoy it. I can't figure out how to comment on the Twitter live stream, says Anna. Yeah, I don't know how the commenting works there either. Cassie Marie says, I like YouTube because I can do other things on my phone while listening. Well, that's great. I'm glad I'm sure you're listening to me right now. I'm thrilled that I'm able to provide a compliment to your morning routine. I also like doing these morning streams because I have a lot that I do during the day, and it helps me a lot to do them in the morning. So thanks for tuning in. Vinny was saying yesterday, Vinny Paulton was saying it was a win for Read. No, Vinny, have me on. I will explain to you exactly why it was anything but. Christina, nice to see you. Christina says, photographic memory. I have always had a great memory with facts and information that interests me. Also, I'm a smoker like you. Yes, smoking towels are good towels. Let's see. Vinny being biased. He's a former prosecutor. He knows better. Oh, I didn't know that. Vinny used to be much better. Now he is a super chat hound. I don't watch Vinny's streams. I don't know if that's the case, but if that's your opinion, let me reflect. More power to you. Let me reflect that they've written to Court TV about Vinny multiple times. Well, the only bad art is art that people don't pay attention to. So the more you write, the more Court TV is going to think that, you know, he's generating controversy. Soil Nina says, thank you, Grant, for answering my questions. Much appreciated. Oh, I'm happy to help. Got a few more pieces of evidence or videos, whatever, I'll throw up on the screen. And then, but yeah, I love answering questions and comments. Kelly Patton says, I love that Grant speaks the truth and smokes as much as me. I'm a chain smoker when I'm listening to anything regarding KR and TB. Yeah, well, I think a combination of my stomach issues and the stress would make anything but smoking during these streams impossible. Had done so, I don't know who that is. Let's see. Oh, all right. We're almost caught up on questions here. Let's see. Hyperobistophilia is people who sympathize with a killer and are attracted to them. Oh, I thought it was like a unique form of memory. And that's strange. I think, yeah, that's strange. I can't imagine something like that. I'm a grantophiliac. Murder by Maestro. You are hilarious. Ditto. Why are they saying it's a win for Read, Dewdrops? Because the tone of the judge was harsh at first, and I don't think the judge really understood that Yannetti had already disclaimed a joint defense privilege, and so judge was like, why is this in here? And now it's clear that it was not a win for Read. It was a win for Brennan in that he's getting documents by Monday between Read and Kearney, those communications, and then only between April of 2023 and October 5th of 2023, though. I think April 1st or something. But if Brennan wants the Yannetti, Jackson, Kearney communications, he's got to go back in front of the judge under a different analysis, which is pursuant to the two cases earlier. One is Fuller, and then there was the other case from 93. I don't watch anyone who puts more time into their neon backdrop than they do on the content of their words. Yeah, I like my world news backdrop. I don't see why people put time into like more than that. Like, you just need a simple backdrop. Will Brennan actually get the bulk of those interviews in? I'm really confused by what he's getting in versus what he's not getting turned over. I can help you with that because there are proposed stipulations in the Commonwealth's statement of the case, and I just looked at that the other day. So why don't I pull that up for you right now, Anna? That's a great question, and let me bring that. Well, first of all, you all watch the end of this hearing, and then I'll bring up the document Anna's wondering about, which is the Commonwealth statement of the case.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Grado. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Bradle. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Read case. This is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Kearney specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that, and we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Kearney's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Kearney. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Kearney's order didn't work either, based on my exhibits A, B, C, and so we're asking for another step to just really put a fine point on it, that these 3 people must stay away, and a general order as well as part 2 is my part 2. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brado. Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding, in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. Again, detail, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed a Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood.
Pause. You know where I'm going with this, folks. I got to do it. It's only one reasonable thing to do in these situations. I must, in the interest of justice, present this for your consideration. Nope, that's the wrong one. We are going to watch that one too. But I must show you this. I must show you this as an expression of my impartiality. I must show you it. We cannot look away. We cannot. Look at it. Now, yes, it was from before Mr. Brennan was involved in this case, okay? But do you understand what that email is? Do you understand what that is? Do you understand what that is? Now, I found it online, okay? But that email could only have come from Karen Reed's cell phone. And it could only be the material that's referenced in the motion that Hank Brennan made, although that was denied, related to Yannetti and Karen's conversations between 129 and 2222. Hank Brennan says in that motion that the Commonwealth got received the contents of the defendant's cell phone because of an observed attorney-client communications, because of an observed attorney-client communication. So a single, after phone data was provided with the phone data was provided with the assent of the defense to the Attorney General, who did a court-ordered taint team protocol. Okay, that communication, folks. There's no way that it's referring to anything other than that email. Okay, so whether Mr. Brennan knows it or not, Like that shouldn't be fucking out there. Do you all see what that's saying? It's Karen saying to Alan Jackson, okay, thank you. And this is on August 26, 2022. Thank you. Just please understand that I am summoning every possible resource to get to the 200K and that David Yannetti is likely out of his league with what this case requires. I just can't have the relationship with David fall apart and resort to a public defender for trial. Holy fucking shit. I also don't want to disclose our fee agreement with David Yannetti since he's already given me a break on his trial fee, 200K versus 250, with 100K signed over from my bail money if we go to trial. Oh, he gave her a deal and she's still talking shit about him. I'm planning on saying that a colleague is paying you, Alan Jackson, directly, which is close to true. A colleague, who I'm pretty sure is Kat, has structured a low-interest personal loan of 200K for me that is payable at maturity. I wonder if Karen ever paid. Did it mature? Did that loan mature already, Karen? Did you pay? So you can see, folks. And then Jackson says back, totally understand, we are good. Folks, that shouldn't be out there. So Hank Brennan, you weren't involved back in when this leaked, in my opinion, because I saw this on social media in early 2024, maybe mid 2024, but maybe even earlier. So actually, Mr. Brennan, I do think I saw this, maybe right around then, maybe earlier. I think if you're true to your word, sir, whether you were involved at the time or not, that shouldn't be public, Mr. Brennan. I think you know that. Little towel. You're always everyone puts a little towel in difficult positions all the time for no reason. Just because I'm a towel. Someone had a question about the Commonwealth's pretrial memorandum, and we will read that now. Let me just bring that up a little bit, and let me make this a little bit less convoluted. All right. Now, just so folks understand, I think there was a question, a very good question about what interviews are coming in, what's not coming in. Here's the proposed statement of the facts from the Commonwealth in their pretrial memorandum. On the morning of 1/29, this is what will be read to the jury. On the morning of 1/29/2022, at approximately 6:04 a.m., the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road within their town. Officers responded and discovered the male party, subsequently identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Miss O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Miss O'Keefe. Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to Good Sam Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with their vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies that she has committed any crimes. Proposed stipulations. The Commonwealth proposes the following stipulation to be entered as evidence at trial. 1. In lieu of testimony by the keepers of record for different institutions where the Commonwealth obtained surveillance video, the defendant agrees to the authenticity of each video. These are proposed stipulations. In lieu of testimony by the keepers of records for C.F. McCarthy and Waterfall Bar and Grill, the defendant agrees to the authenticity of restaurant receipts. In lieu of testimony by the keepers of records and in lieu of testimony from any defense counsels, the defendant agrees to the authenticity of her audio and video recorded statements made during interviews with reporter Gretchen Voss, reporter Matt Gunman, reporter Dennis Murphy, and reporter Ted Daniels. This stipulation also includes any recorded statements made by the defendant to ABC, including ABC News 2020, Good Morning America, NBC Universal, including Dateline, and any statements of the defendant to Terry Maurer, Unsolved Productions, or appearing in A Body in the Snow, the trial of Karen Reed, appearing on Investigation Discovery HBO Max. So that covers a bunch of different individual interviews and broadcasts, and then also Karen Reed, The Perfect Storm, The Night of the Nor'easter, and A Body in the Snow, the trial of Karen Reed. Nobody mentions John O'Keefe in the title. What the fuck? In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of statements attributed to her in a 2-part Vanity Fair article titled Karen Reed Tells Her Story, A Murder Trial in Massachusetts. What the fuck? Nobody uses John's name in the title. It breaks my fucking heart. By Julie Miller, published on October 29, 2024 and October 30th, 2024. Look, even below my head right now, even just in my stream titles, I try to be very cognizant of including John's name. They don't even put in the fucking titles. In lieu of, you can tell him an incredulous little towel at that. And by the way, cursing, I found out after doing some research into the Bible, is not necessarily a sin. It's only a sin if you curse or invoke God's name in the interest of malevolent ends. And I'm being benevolent in my incredulity, so I can say the F word. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of William Reed, Janet Reed, and Nathan Reed's recorded statements, audio and visual, to Ted Daniel in Boston 25. So just so folks understand, that was the answer to the question that came up. If Karen agrees to all of these, then yes, they're all coming in. Brendan obviously plans to use them all, so this is a pretty good hint as to what we're going to get. And if Reed doesn't agree, Brendan's going to authenticate them, and it's going to take a while. We're going to have to call the keepers of records. We're going to have to subpoena all these people. They're going to have to fly in. It's going to be a whole process, but Brendan is saying he's going to do it. Mind you, Reed's defense counsel are on the witness list too. And it doesn't matter whether Brennan's motion related to Yannetti's contacts with Reed was denied. Brennan can still call the defense counsel if there's no other way to authenticate the statement. So it behooves the defense to agree to stipulation 3, but they haven't yet as far as I understand. 6. The parties agree that the known DNA standard for John O'Keefe may be admitted without testimony from the forensic scientist, Ms. Sophie Hazen, that created the standard. The parties also agree that the standard may be used and referenced by analysts from the MSP Crime Lab, Bodie Labs, and UC Davis Veterinary Genetics Labs when they testify to their work, analysis, and conclusions based on samples in this matter, including making statistical opinions based on the standard for John O'Keefe. That's about John O'Keefe's DNA being found on Karen Reed's car, taillight area, bumper. And other relevant analyses. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of her medical treatment records and the medical treatment records of John O'Keefe and the admissibility of such records subject to appropriate redactions. Yep, that's coming in. The BAC is already coming in, so that's coming in. And medical records are an exception to the hearsay rule, so they come in automatically anyway. In this case, to get them in, though, you have to authenticate them, and that just prevents the keeper of the records from the hospital from having to come in. It shortens the trial. This is how Brennan's going to get his case down to 3.5 weeks, if Reed agrees to all this. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of reports generated by the Canton Fire Department. In lieu of testimony from Andy Klein and Mike Mirioli, the defendant stipulates that on September 23rd, 2024, Acupuncture LLC inspected, photographed, measured, and laser scanned the defendant's 2021 Lexus LX570, John O'Keefe's 2019 Chevrolet Traverse, and area outside 34 Fairview. On October 2nd, 2024, the driveway and surrounding area of 1 Meadows Ave and Canton were photographed and laser scanned. That has to do with Karen's Lexus GPS data, the proving via that forensic data that Karen did not break her taillight by staging a bump into John's car at 5:08 a.m., that Karen's taillight was definitely broken by the collision that occurred while Karen was reversing at 24.2 miles an hour at exactly 12:31 as it turned to 12:32 a.m. on 1/29/2022 when she crashed into John. And by the way, Karen's own experts from ARCA testified that Karen's taillight could not have been broken due to a low-speed impact between 1 and 5 miles an hour, as was indicated on the ring video. That was the only ring video of 18 ring videos, or 18 ring videos, recorded between 12:37 a.m. Karen's return to John's home in Canton after she allegedly struck John, and that's about how long it takes to drive from Fairview Road to 1 Meadows Ave, about 5 to 6 minutes, 4 minutes and 50 seconds or so to 6 minutes, depending on the route and depending on the conditions and the traffic lights and all of that. Okay, so there's 18 ring videos between 12:37 a.m. and 5:08 a.m. when Karen leaves and backs up and stages that bump into John's car. 17 are deleted. Wonder if Karen deleted those videos. I have a feeling she did. And unrecoverable, by the way. They're unrecoverable according to Adam Lally's inquiry with Ring during the first trial. By the way, let's take a look at the Karen Lexus data, a little preview of what could be coming in about that. And then while I do that, I'll get us caught up on comments, and then I think that pretty much brings us up to speed. But this is the big news, folks, because I don't know if you've seen my coverage of this before. I really, truly believe that we are going to see something explosive that might reflect the map on your screen as to Karen's route of travel going back to the scene at 5:23 a.m. on 1/29/22 to confirm John was dead before going back to Fairview, before going to get Jen McCabe. And then taking Jen McCabe and Carrie Roberts back to Meadows Ave. The murder weapon was dropped off, allegedly, by Karen. Karen gets in Carrie Roberts' car. The women drive back to Fairview Road, and then Karen sees John's body somehow through a blizzard in the dark on the front lawn before the women pass the tree line of the home, and that may explain it. So let's listen to Hank Brennan talk about some of this data. I know this is Murder by Maestro's favorite thing to talk about in the entire world, so.
All right, so let's talk about the Commonwealth's notice of scheduling reassembly and testing of the defendant's Lexus telematics system.
May I?
Yes.
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities.
Pause. Okay, I want folks to understand very carefully what's about to be explained here. There's a lot of nuance to this. I'm going to take you through it, and let's think about this. Key pieces of the evidentiary record to keep in mind. During Karen's first trial, this data was chipped off, so it was extracted from the infotainment system, okay? But only 2.4 gigs of data was recovered. Why? Because of the 3 chips, only sectors from the first chip were read. Now, you might say that's weird. Did the state just not, was the state unable to do it? No, the state allowed Karen's expert to do the first chip off of the infotainment system, and somehow Karen's expert was trusted when that woman said, I think it was a woman, that she was only able to obtain 2.4 gigs of data from one of the chip-offs due to bad sector reads or something on the other hard drives. How convenient for Karen, right? And Adam Lally, I guess, just let Karen do this. Well, Hank Brendan said, I'm going to bring in my own expert, and we're going to redo that chip-off. And guess what, folks? Guess who won the pony? Back in November, we found out, which was just a preview, that Hank Brendan got 8 gigs of data from a rechip. That means all 3 had sectors that were readable. Now, why Karen Reed's expert was unable to pull that off the first trial, it makes me wonder. There's a lot there, but it's irrelevant to the point, which is Hank Brennan's got it now. And guess what it has in it? GPS data for that car, not only at 12:31 a.m., but throughout the morning. The best laid plans of mice and men, folks. The best laid plans of mice and men. I'm just a vagabond with flowers for Algernon.
What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips.
Wait a minute, I didn't even catch that the first time. Did you all hear what he just said? Hank Brennan said that it wasn't just that only 1 of the 3 chips was read. The reads expert used the wrong software or the wrong chip reader, which is hardware. Oh my God. Oh my God. Oh my God. Murder by Maestro. You were right to be yelling from the rooftops about this, my friend. I will tell you right now, you nailed it right on the money. Could not be any more prescient. Nailed it. Nailed it. Nailed it. Absolutely 100% nailed it. There is a lot there, folks, and we haven't even heard the disclosures about what this detail is going to contain. I have my prescient forecast based on my extrapolation of all of the evidence in this case, being one of the few people who has read every single fucking thing on this godforsaken 700 item docket at this point. But I'm telling you, folks, I'm telling you this is huge. I'm telling you now that it's huge, because it wasn't just the chip off was incomplete and only 1 of 3 chips was extracted and read. It was that the wrong software was used initially too. Oh my God, it was definitely, I have a strong feeling Karen Reed's expert was like, oh my God, I can't believe Lally's letting me do this. Let me give myself some plausible deniability. Well, Brennan's got all 3 chips now, and the data went from 2.4 gigs to 8 gigs. Oh my word. I'm so glad we watched this. This was back from November too. See, you got to watch. Karen was right about one thing I've seen her say in an interview. You got to watch every fucking day of this case. And even when you do, you might not truly pick it up. You got to watch every single day, because it's not like something just gets revealed at the last minute. It all stacks on itself, and you might get this explosive bombshell that's lingering like a latent time bomb, just hanging out there. You heard it in November. You didn't necessarily see it referenced yet in another motion, but my God, folks, it's coming. It's coming in trial. It's coming soon. We're going to see it. We're going to hear it. We're going to find out about it, and it has to do with GPS and also John's phone unplugging and plugging from the Karen's car, the Bluetooth. But let's keep going.
The download that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them this is what we were going to do. You can see from my motion I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize the Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they were entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information.
Oh, I remember now. Okay, so this was the motion which eventually gets granted, where Hank Brennan is allowed to do the chip off from Reed's Lexus, and Reed just ends up getting the concession of her expert for this time around can just watch. And they go to Texas. They do it is destructive testing, so it means the board's consumed during the testing, but they do the chip off. Brennan comes back in December and reports that indeed, they were able to pull it off. But let's listen to more, because this is great background.
Both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for them, what their position is today. But I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested. And it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights, and that's why we now have an independent expert that is going to do this. I know experts differ. They're not frick-a-frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing, and the reason I brought it before the court is I wanted to expedite this matter. It's important, and it does.
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's
moved to April 1st.
Still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible.
And so that ends up getting done in December, and that's good context for what we were looking at there. And so I want folks to keep a close eye on that. We looked at that. We looked at the video of Aidan. We looked at the Jim Miller situation. We looked at the Commonwealth statement of the case. We looked at the complete Karen Reed search warrant affidavit. We looked at the overview of the judge's order for material from Kearney and Karen going to Brennan. Okay. So this is the motion. This is the last thing we'll read today. We're going to close with this. I'll read some comments before this, and then I'll circle back with you all tomorrow, and we'll do a stream on just the ARCA situation, and then I'll do a lot of predictions. And by the way, I just want to thank you all so much. Somebody asked for the PayPal earlier, and I put it up, and someone sent a donation that I sometimes, whether it's like $1, $5, I look down and the donation comes up and I'm like, as I'm watching the video, and you might see me like smile and do the cross. I'm not doing it in response to the video. I'm just so grateful in that moment, and I can't interrupt the video to say thank you, so I'm doing it now. I'm going to read back some of your comments, though. I'm sorry I haven't been following your comments in real time, so but I am going to read them back. So hold on. By the way, when people make comments about like neon signs and stuff, I have no idea who they're talking about. Like they could be talking about a Karen Read channel, Justice for John O'Keefe channel. I have no idea. Let's see. Okay. Bella Davis said, let's see. Bella Davis said, I'm just confused. Murder by Maestro said, Belle Davis, you are watching a man who thinks he is a towel, who is reporting on a murder trial involving a man who thinks he is a turtle. I didn't say I think I'm a towel. I said I'm an anthropomorphic towel. And the origin of that, of course, is that the TurtleBoy fans mocked me one time for something, and they were like, Grant's pronouns are towel, and I was like, okay, I'll just become the towel from South Park. He seems to get high and then randomly solve complex social problems, and he's also a government-created robot towel. So I just thought all of it was very nice. That's the best I can do in one sentence, says Murder by Maestro. Belle Davis says, that's hilarious. I agree. Even it's what we call moments of levity, despite the otherwise serious nature of this historical conflagration as manifest in Joycean cycles of Hegelian proportions as to the synthetical synthesis that seems to merge Karen Read's inevitable defeat at the hands of Truth's boulder in this Sisyphean story, and Hank Brennan's perpetual quest for using the weight of evidence and his knowledge of the intricacies of the socio-political historical dynamics at play at this case to ensure that boulder rolls down the hill in such a way as Reed, in order to actually get over the hill, has to learn that she must tunnel through and go through atonement and apologies and that catharsis which has been so denied to the family of John O'Keefe, if indeed she wants this boulder to stop rolling down the hill and crushing her with the weight of Truth's inevitable sublime beauty, then she must tunnel through that hill. And it's a laborious process. There's a reason why it takes a lot of effort to tunnel through a hill. But yes, these are what we call moments of levity among that otherwise tormenting Joycean cycle, which really does a good job of embodying Vico's recursive historical synthesis, which I think was somehow either reflexively embodied in Hegel's thought, or Vico was adapting Hegel's thought for a more applied formula. Of course, Hegel didn't write anything down, so the only books we have about Hegel are his students' lecture notes. But Vico's theory is a lot more accessible. History as a recursive circle, and I think if you think of history as a recursive dialectical circle that tells the tragic tale of the rise and fall of human morality over and over and over and over again, then that makes the wake, Finnegan's Wake, a lot more accessible. You'll never be want for a discussion at a New York Society high fashion party if you can explain the historical context of Vico's recursive circles as a layperson's framework for relating to the historical mosaic that is Finnegan's Wake. But as a sort of allegory to the Karen Read trial, if you want to understand the Wake, what the Wake is really about is this guy named Humphrey Chimpton Earwicker, who I think kind of gets like cucked by his wife or something. It's a little bit of a weird story, but he like gets really like upset about that, and so there's this river that flows through Dublin, and Joyce starts the story by like in the middle of a sentence and by saying like, and thus like a commodious vicus of recirculation, we arrive past Bendith Bay and shore and Adam and Eve, and because Joyce is comparing Humphrey Chimpton's Earwicker's 24 hours to the river, but really it's about more than that. Okay, the story is Humphrey Chimpton Earwicker, his initials are HCE, and his wife is Anna Livia Plurabelle, ALP, and then their children are like Sham and Shem or something. Okay, so this family Humphrey Chimpton Erwicker like goes to a bar and like tells people about his life, but really what the story is about is they emerge in like these family members emerge together in these historical cycles. They're like Shaman Shem the Penman from the Bible with their parents, or they're like Napoleon and his like cohorts like getting ready to take over Europe. They're simultaneously like privy to the downfall of Marie Antoinette and the rise of the French Revolution. They just have these sort of historical recursive embodiments that Joyce uses to tell allegorical moral lessons. Okay, so for the Karen Read trial, I sort of interpolate that, and my philosophy of history, my applied philosophy of history that I do, will be to do things like in my writing compare Karen Read to things like Sisyphus and Alan Jackson to Icarus with his singed wings and the boulders of truth. Or I'll build in something like an allusion to Karen Read being Pip from Great Expectations, with Hank Brennan being Miss Havisham tormenting Karen for her sins. For Karen's sins, even though Karen is Pip, who is a boy in that story. Or I'll have Karen pop up as Irene Adler, the foil to Sherlock Holmes, her Holmes referred to as the woman from the excellent A Scandal in Bohemia. And you should watch the 1984 Jeremy Brett adaptation of A Scandal in Bohemia if you want to watch what I think is the best film adaptation of the text that you can possibly see. But in this case, I flip it, and instead of Irene Adler besting Holmes by taking the picture of the king that she was using for blackmail in that article, the king of Bohemia had retained Holmes as a client because he was being blackmailed by this woman who turns out to be Irene Adler. Adler realizes that Holmes is coming with this funny disguise, and Holmes stages a fire in her home to try to steal a picture of the king that Adler was using as blackmail. It was just them like sitting on a chair or something next to each other, but they were having an affair, so it was a big deal. When Holmes opens the safe after Adler flees the home, he finds that she left with the picture. Adler writes him a note being like, I burned the picture, but and the king ends up paying Holmes and saying that's enough. But the reality of it is that Irene Adler bested Holmes in that story. I invert that and frame Brennan as Holmes outwitting Adler, because I think he did indeed outwit her here. But you can see what I'm doing. I'm mirroring the Joycean narrative, and I'm taking the same characters and overlaying them on a recursive historical allegorical narrative in order to tell a story of the rise and fall of human morality, and also the asymptotic character of universal truth in relation to the way human beings understand and process the temporal world around them. And in particular, how sort of non-temporal, I think, themes, things that are beyond our ability to touch, see, hear, understand, or whatever, are actually the unifying underlying insight about my work. There is something bigger than just what we see on the surface, and if you will really get rewarded if you're reading, especially reading my written work, you'll get rewarded if you're looking for hidden allusions and layered meaning, because any good work or text, in my opinion, or oration should encode layers of meaning so that you as the listener or reader are being rewarded for what you bring to the text. I will spoon feed you certain information that I feel will interpolate complex legalese into accessible lay language to engender your standing and participation in the democratic process. But I'm not going to spoon feed you literary and historical analogies that are nestled within the work. They're there for you as a reward for you being well-read or continuing to engage with historical material or precedent or books or movies. That is your reward. That is how a well-functioning society should operate. If you are engaging with that material, reading the case law, reading the precedent, reading the history, reading the philosophy, reading the sociology, if you're understanding it all and then you're reading my work and getting rewarded for it by seeing the nestled allusions, then I have done what I set out to do, which is to help make you a more active, learned, cogent participant in the democracy. And then I've also made sure that the history that is so important to understanding every human interaction, even though they come up in different contexts, does not get lost. And we continue to take these lessons and apply them as we're studying events unfolding in real time. That's really what I'm trying to do. I'm trying to understand truth and then apply a quantitative formula for helping the public engender their standing in our larger democratic process so that you guys together can all ward off usurpation of our representative form of government. I don't care what fucking opinions you have. You can come to believe whatever the fuck you want. That is not my job to tell you what to think. I'm trying to give you the form of an analytical approach to understanding material that you're consuming so that you can then take it, go out in the world, empower yourself. Hopefully don't use it for malevolent ends. I will be very frustrated and upset if you do, and I'll critique you and call you out. But I hope it empowers your participation in our democracy. And I really think that's why Joyce's insights from the wake, although he was very paternalistic with it, are so important. If you can encode these analogies about human morality into language that is easy to understand and in the form of stories, then really you've helped to right egregious moral wrongs and also enable people to go out in the world and do the same. And there's nothing that could make my life more fulfilled than doing that. That was quite a speech. I don't know where that all came from. I feel like I was acting like a bit of a conduit there. It's all up there somewhere. I don't know why I was relaying that in that moment. Maybe some of you out there needed to hear it. Maybe you were wondering, why does Grant layer complex literary allusions in his writing? Now you know. Let's say, Murder by Maestro says, this all makes more sense with the doobie. I don't know. Yeah, I guess so. Let's see. We had so many comments. I'm only going to stay with you for a few more minutes. I'm obsessed with U.S. trials, says Belle Davis. Yeah, I'm interested in international geopolitics and the way in which statecraft facilitates the protection of U.S. national security and the expansion, demonstration, and preservation of American interest. Not corporate interest, the interest of this republic that I love so dearly. The UK is okay. For me, if I ever got elected president, I would embody the Jack and Mac relationship between JFK and Harold Macmillan. I thought that was the apex of the special relationship as to the sharing of Trident and Polaris and the dual key technology that really helped the UK to preserve its prestige on the international scene after Suez in '58. I personally don't think that the UK would have maintained, outside of its financial dominions, much international hard power post-Suez in '58 without Trident and Polaris. But the reason why they're dual key technologies is that the UK was incredibly weakened after what Nasser did to them in '58. That was just the worst thing possible that could have. It was the worst way for the British Empire to end, although it formally ended with the handing over of Hong Kong in '99. Makes me so sad because one of my favorite books is The Rise and Fall of the British Empire. Actually, hold on one second. I know some of you are British, so I'm taking an aside to do this because it's someone was like, I like U.S. trials. So this is my favorite book. Let me make sure I can see it. This is my favorite book. It's one of my favorite books. It's a very long book, but I love it for so many reasons. But one of the things that I find so sad is just the way that British prestige fell off after Suez. But I would embody that Jack and Mac special relationship and help bring back the UK to its international prestige. I'm trying to find this part in this book that I like so much. There's this, I don't know if you all know, I don't know if any of you are from Virginia, but I can actually tell you the reason why why Virginia is named Virginia. It's actually quite unfortunate. Well, I guess we won't say that it's unfortunate, but it's one of those things where I love this book, and now that I have it here, I just must read this quote for you all. And you can blame, I guess you can blame, you don't have to, the people from the UK who made me look up this, because it is one of my favorite things to read. So I'm going to explain to you why Virginia is named Virginia, and you'll never think of the state the same way again, although it's eloquently phrased though it may be. Let's see. Is it page 10? This is my punishment for not having read this book in the past 12 months. I can't instantly recall what page the interesting paragraph I want to work is. Hold on. Where is it? Let's see here. Nope. this is not perfunctory either. It's just I really, really want to give this interesting lesson about how the UK manipulated its workforce and population into going to America. So it's either page 35 or 38. There's only so many references to the state of Virginia in here. So there's got to be one of them. Right, where is it? This is so frustrating. But yes, the line that I really, really like in here explains, and even if I don't find it right now, that the origin of the name of Virginia came because they wanted to sell indentured, or they wanted to sell coal miners around Newcastle on the idea of a virgin maidenhead. And so this Virginia was more than just an ode to Queen, the Virgin Queen. It was indeed, whatever her name was, it was indeed also an attempt to sell the British population on this land as a virgin maidenhead. Well, there you go. You can see how frustrated Tal gets when he goes to research something and can't find it. But you know what? That's just a part of life. All right, I'm going to continue reading your questions. And that whole digression came simply because someone said they were from the UK. So I'm sorry I couldn't find it. Let's see. Like her, please can someone change my mind rationally? What are we changing your mind rationally about? The given evidence of her guilt is impossible to ignore. That it is. That it is. Hold on one second. I'm sorry. When it comes down to something like this, I can't just leave it. If I set out to find it, I am going to find it, and I'm going to find it by the word maidenhead, because there's no way he uses the word maidenhead more than once. Although I don't think you actually have to reference maidenhead, because maidenhead is not, it's just a term, it's not a thing. But yes, keep asking your questions. Hold on, I'm not giving up. I just am intent. I am intent on finding this reference, and there's nothing you can do about it. I think I found it. Let's see. You're all like, why is Grant reading this book? But it just frustrates me so much that something like one of my favorite citations, like something that I bring up all the time, I have just lost. I know it is in this book. All right, but it's not fair for me to do that to you. We'll read the ARCA motion, and then I'll get out of here. Grant, we don't have to wait for you to do that. But I wanted to talk about how Virginia's origin had to do with the Virgin Maidenhead. But let me read some more of your comments. All right, let's see. Could have been caused by the car. Numerous examples. No, it's not a botched it's not a botched investigation. There will be no not guilty. At the best, it'll be a compromise verdict on count 2, probably OUI manslaughter if Karen doesn't take a plea. Let's see. Haven't seen Kat since the trial. Yeah, Kat was the one who gave the $200,000 loan. Let's see. The Lexus data is not botched. Yeah, it's definitely not botched. We already have it. I believe the trial will convince you of her guilt, Belle. It will start soon. Keep an open mind. Belle, we won't attack you or degrade you or be mean as most supporters do. We just want the truth. Yep, you can have whatever opinion you want. Let me be frank with you. Leaf blower to look for plastic is fine as long as it's documented. I tend to agree. True, but people keep moaning about it. Yeah, I don't think it's a big deal. Yeah, if you're telling the truth, says Dixie Doodles, your story doesn't change every time you speak. I agree. I agree with Dixie Doodles. The trial, it says Kelly Patton, the trial will convince you of her guilt. So much has changed, and the defense lied regarding their witnesses and had witnesses lying too. Yep. The truth never changes. Thank you, Kelly. Which witnesses lied for the defense? Definitely the ARCA witnesses materially withheld the fact that they were promised future compensation. Lucky Lofgren lied and then was corrected on cross about the timeline that he arrived at work. He got to work after like 1 or 2 a.m. He saw a black car around 5 a.m., not 2 a.m., and that black car was likely Karen's Lexus going back to the scene at 5:23 a.m. to confirm John was dead before Karen drove over to Jen McCabe's at 5:35. As to who else, Richard Green blatantly misled the jury on the stand about Jen McCabe's 6:23 and 6:24 a.m. Google search, as confirmed by Ian Whiffen from Celebrate and Dr. Jennifer Hyde, both of whom explained to the jury, and the jury didn't even think that anything else other than a 6:23 or 6:24 a.m. Google search happened, because that was the only Google searches that Jen McCabe made about how long to die in cold at Karen's request while standing at the scene of John O'Keefe's death, where Karen had driven with McCabe and Carrie Roberts after dropping Karen's car off at One Meadows Ave and then going back to Fairview, whereupon Karen saw John's body through the dark in a blizzard on the ground when she returned with McCabe and Carrie Roberts. So Richard Green completely misread a write-ahead file in the WallDB Celebrate GUI, and as a result, he misled the jury very much about the 6:23 Google search and tried to imply that a 2:27 a.m. Google search for Hawk Mock Sports that Jen McCabe had done earlier in the morning somehow had to do with the 6:23 a.m. and 6:24 a.m. searches, when in fact Green misread the write-ahead WallDB file so bad that Celebrate had to update its GUI graphical user interface so that would never happen again, because of how badly Green misunderstood the data that he was looking at. And mind you, Richard Green himself testified that he had to reach out to Celebrate chat support when he had questions. And Ian Whiffen, the person who pushes commits and is the internal in-house expert on Celebrate, one of the foremost recognized tools for data, cell phone data extraction internationally, that is actually a combination of a suite of different tools that kind of serves as like a plug-in interface. And Dr. Jessica Hyde, by the way, is an even more comprehensive expert, because she specializes in all the tools that interface with the Celebrate interface. Both confirmed that Green was wrong and that the searches were at 6:23 and 6:24 a.m. So you had that, and then, oh God, who did Karen even put up? Oh, and then you had the fucking dog bite woman, who the jury completely discredited because she came forward in the middle of trial. She's got these weird connections to the LADA's office where Alan Jackson's wife either worked or still works. So there wasn't a single witness Karen put forward in her defense who didn't in some way try to mislead the jury. But yes. Let's see. Hank Brennan, we have the time and place. Yep, they do indeed. Barb says, I missed this about the vehicle data. When was it? I think that was in November of 2024. 2024, yep. This is a heartbreaking case. The things Karen has done encourage others to do on her behalf, attacking the family and the witnesses and their family. Do we have hard evidence of this? Oh, yes, a lot. And just about anyone who thinks she is guilty, an innocent person wouldn't be okay with that. She is not okay. She is not okay with it, but she encourages it. She's not only okay with it, but she encourages it. That's a good point, Kelly. Hello, Jeff Williams. Good to see you. Murder by Maestro says, spot on, Grant. Someone says, wow, great. I don't know what I was saying at that time, but thank you. Did Nate have a hand in the first search? Her sister, yeah, her brother Nathan. Yeah, I think he was there in the afternoon when they picked up the murder vehicle. I'm glad there's a second trial with all this coming to light. Yep, I agree with you. There's evidence, says Kelly Patton, of everything, including how the lies in the last trial, as well as their witnesses. Yep. Oh, yeah, the ARCA misleading the jury about contacts with Reed's team and all of that. Flowers for Algernon was my favorite book when I was younger. Yeah, that's a great book. I'm like a vagabond with Flowers for Algernon. Remember when the CW claimed there should be more data and Karen's team smoke screened it? Yep, I remember that. Oh, this is changing my mind. Oh, okay. I say lots of things. Well, maybe the chat was changing your mind, but I also say lots of things that I hope change people's mind. Someone said explosive indeed. Jeff Williams said, wow. Bell, you should watch the Dewdrop says, Bell, you should watch the first trial too, and then what's coming up now. It does take a lot of time. Yep. Murder by Maestro says the Lexus data is legit. I agree. Maui Swift says I knew that. Let's see. GPS data, etc. says Frank. Yep. Murder by Maestro says, yay, Grant sees. Oh yeah, the Lexus data. Grant definitely sees. Was this before my long soliloquy about human morality? I can't wait to read the comments about that. I thought it was because the software hadn't been updated yet. Now I'm confused. No, those are two different things. One's the text stream data, one's the infotainment data. Do you think she intended to hit him? I think she was pissed in the moment, like he was breaking up with her, she was losing control, and I think she was angry. Intended to kill him? I don't know. Hit him? Minimum accident, at worst reckless behavior, and she should have known better, which makes it murder too. By the way, in Massachusetts, the third prong of reckless the malice second degree murder does not require intent to kill. You can get there by a recklessness mens rea, where the person does an underlying reckless act, to wit, in this case, backing up a car while drunk to 24.2 miles per hour while another human was around it, that a reasonable person, so not a drunk person, but a reasonable person, knew or should have known in that moment could cause a strong and plain likelihood of death. So that's why she's charged with murder too. She doesn't have to have intended to have hit him to have murdered him under murder too. Using the correct software, it will open in a map and show data for each point, says Murder by Maestro. Oh, wow. Dixie Doodle says, thank Hank. Maui Swift says, Lally is as naive with these dirty. He may have been a little naive. I think he was just overwhelmed. I think Taylor says, I think she meant it to hit him on purpose. I don't think she realized it would kill him. Yeah, maybe. I think that's possible. Let Me Be Frank said it's going to be beautiful. The data, be honest, says I can't wait. Murder by Maestro says I'm ignore my typing. I'm in the garden with you all. Are you a garden gnome? Kelly Patton says, Bell, initially I thought she did, but thought it was an accident. Now that her true colors have shown, I think she meant to do it. Well, meaning to hit him and meaning to kill John are two different things. Why do you think they are fighting Dr. Judson Welcher? Oh, is that the expert who will testify about the hardness of the ground? If so, that's the reason, because it goes directly to what caused John to die, hitting his head on the ground after the collision and then the cold. All the evidence points to the defendant. Fact, I agree. I love Hank's voice. I agree. Like a heat of the moment type situation, says Maui Swift. I agree. When they did see the GPS pointers, they should instantly have realized. Now think of all this from Trooper Paul's perspective. Yep. Hank, born in Ireland. Yep. They managed to restrict the investigators' access to evidence, not a jury or an expert, but the investigators. I agree. Dixie Doodle says this is big. I agree. Oh my God, there were a lot of comments. Oh goodness, there are so many comments. Hindsight is one of the keys. I agree. They're stocking the war room with more Tito's as we speak. That's funny. Heat of the moment made harder with the excessive alcohol. I don't think she really thought he would die, but I feel it was a moment where she snapped and couldn't control it. I agree. Nathan took a plea, her brother, as to like embezzling money from like a college bookstore or something. It wouldn't surprise me if he pulled strings for the chip off. Maybe he does have Lexus friends. Nathan Reed works at a Lexus. Grant, you are amazing at breaking it all down and helping us to understand. Oh, thank you so much. You're all so kind. And I also want to say thank you so much. Someone sent a PayPal donation earlier after I put the information up on the screen, and someone else sent a Cashapp, and it means a lot to me that you all find this useful, and I do my best to try to keep it up. And if you like this public information service, keep commenting, like the YouTube video, subscribe. There's lots of ways you can help. You can help offset server costs. You can do all sorts of things, and every single one of them, the chats or otherwise, is touching to me and means a lot, especially the donations too for right now at the end of the month. Those are very touching. The blogger is in big trouble. I agree, Jeff Williams. Let's see. Someone said, Maui Swift said, I agree. Karen is freaked out and was afraid to confront what she may have done, hence her cover-up job. I agree. What she did is the same as pointing a gun at someone, shooting them, so the shooter didn't expect the victim to die. Similar but different. Someone said, oh my God, listen to him. I don't know what I was saying, but okay. Let's see. Murder by Maestro said, there is something powerful in the phone temp of JLK that nobody has touched on, by the way, that can be presented to the jury. By naming the dropping temps, it puts the jury right there in the cold alone. Agreed. That's agreed. They're going to use John O'Keefe's phone temperature, not just to show the phone didn't go anywhere, because that's what the GPS data shows, but also that that it was cold. It was cold, and John died a lonesome death, a very sad, lonesome death at Karen's hands, in my opinion. Grant, you should be a professor. I'm just a towel. Barb says she pointed a 600-pound murder weapon at John. That is true. This isn't one for the layman, is it? Well, I think it's one for a bit of both. Rest in peace, John O'Keefe, says Drew Drops. I agree. Frank says, I want to know if John, his phone tied to connect to her Bluetooth in the alleged second time she drove by. Oh, that's a good point. Did John's phone connect to the Bluetooth at 523? That would be big, Frank. Great intuition there. That would be big if confirmed. They can't remember anything when they're drunk. Yeah, that's true. I agree. Karen probably didn't remember a lot, but I couldn't very well be wrong, and she could have done it even sober, especially if more of her true colors are revealed. Perhaps. Hopefully Peggy and the O'Keefes will get justice they deserve. I agree, Jew Drops. Grant, you are astoundingly well read. No, I'm just a towel. I'm still so frustrated at myself that I couldn't find that reference that I wanted earlier, and I was like, I'm going to find it on another stream. But you know what? I think it was actually just a little bit later in the book or something, and I shall not be deterred. You all have brought this upon yourself, especially if you're British. And I don't mean that in a bad way. I just mean it's not that I'm well read. It's I'm compulsive about information. And if I learn something, especially something really interesting, and I want to, tell people about it, I have like a photographic memory of what it says. And if I can't relay that exact information to people, I get really frustrated because even if I summarize it, I still just get incredibly frustrated. You did this to yourself, though. You did it to yourself. Let's see. I think I might have actually found it. Let me see. I was not going to give up. It's in this part where I found it. I found it. It's on. Thank you so much, Belle Davis. You have made me locate this quote after hours of searching. It's on page 12 of Lawrence James's book about the rise and fall of the British Empire. And we are reading this quote now because Towell, in his undeterred quest to find this, has found why we had named Virginia, why the British named Virginia, Virginia. The conceit that the American continent was a richly endowed virgin bride awaiting a husband enjoyed considerable usage at this time. It was not just a courtier's knack for flattery that had inspired Walter Raleigh to name the eastern seaboard of North America Virginia in honor of Elizabeth I. A deeper meaning was intended since Raleigh, in his plea for the occupation of Guyana, had described it as a country that had yet her maidenhead, never sacked, turned, nor wrought. The face of the earth hath not been torn, nor the virtue and the salt of the soil spent by manurance. In coarser vein, Captain Siegel rallied the settlers in Eastward Ho with the cry, "Come, boys, Virginia longs till we share the rest of her maidenhead." Most famously, the likeness of America to an unblemished maiden is employed by John Donne, among other things a chaplain to the Virginia Company, in his To Mistress Going to Bed, in which the seducer is both explorer and planter. License my roving hands and let them go, before, behind, between, above, below. Oh, my America, my new-found land. The moral question faced by Englishmen was, by what authority could they claim the fertile, untilled lands of North America? A broad and infallible answer was provided by the prevailing view of the divine ordering of the world and man's place in it. God, wrote John Milton in A Defense of Colonialism, having made the world for use of men, ordained them to replenish it. Well, there you go. That was the part that I was intent on reading, not so much for the defense of colonialism, which I don't support, but more for the origins of the state of Virginia. And now you know, folks, you're nothing more than British subjects living under a bunch of nomenclature that facilitates the existence of a modern aristocracy in America, hiding in plain sight. And by the way, I thought titles of nobility in America were banned. That is not actually true. I do have to let you all know that you can have a title of nobility and be an American citizen. And that was because the title of nobility amendment failed when it was presented for initial passage. However, you can't have a title of nobility if you're a constitutional officer or otherwise hold a position of public trust in the United States. I hope that was edifying. Okay, let's see. I'm going to skip forward in some of the comments. Great speech, Grant. Oh, thank you. I hope you enjoyed my speech. It was a good speech. Grant is too intelligent for me, says Barb. I don't know. I don't remember what I say when I'm delivering those orations half the time. Someone says, and me, Barb. Let's see. Gotta say, gotta love Grant. Oh, thank you. I've had tobacco from Virginia. I don't think that's actually, well, it might be from Virginia, but Virginia Gold is not actually from Virginia. Murder by Maestro. They are not consistent with being hit by a car. I agree. John's injuries are consistent. I'm sorry to hear you've been hit by a car, but John may have had his arm out. And the taillight was broken. There's any number of ways that those injuries could have been caused by the car, and we will hear testimony about this. Let's see. Grant is spot on. Elizabeth I, the Virgin Queen, because she wouldn't put out. Well, it's not just that. It's more just, as we learned, Murder by Maestro in the Lawrence James's excellent book on page 12, paragraph 3. It was more that Virginia was being sold, America, the Eastern Seaboard, Virginia, when it was originally a state, was fucking huge. Massachusetts used to go out to fucking like Pennsylvania or something. And we used to own Maine, too. We got it for $1,200 or 1,200 pounds sterling. It was a good deal. I'm a fan of Massachusetts annexing Maine again. I think we can just take the burden on of Maine and take care of it. We should offer a little bit more than 1,200 pounds sterling. First of all, I don't think sterling's a currency anymore. And second of all, if you had pound sterling, I don't think you could buy Maine with it. Is that legal currency? Can you tender pound sterling to purchase the state of Maine? I'm sorry. There's your moment of levity, along with your donation reminder for the wonderful public information service run by Towel. You all are so kind and funny in the chat, even though these are very tough subjects. I'm skipping over some of the chat. Let's see. I wonder if I'm going to get to the part of the chat where I discovered the Virginia Club. Oh, goodness. A lot of people talking about Karen, wishing supporters would actually listen. Wishing Karen supporters would listen to the facts. I agree. That is important. All right. God save the Queen. Grant's breath of fresh air. She was a proper prude. All right, folks, listen, you know what I'm going to do? We're going to pause for now. There's one more document we're going to come back and talk about, which is a bunch of admissions related to ARCA. We talked about how the Read withheld a lot of material related to ARCA in her response, by the way, and that I referenced earlier, to the state's discovery request about ARCA. And just to tell you, ARCA has to undergo a mid-trial voir dire before they can testify, because prior to the first trial, ARCA was subject to a voir dire for a Rule 14 violation by Read, reciprocal discovery. And then during that voir dire, the state was disadvantaged because Read continued to withhold information, including about a $26,000 retainer, which is strangely very similar to the de-obligated funds for ARCA's contract for the John O'Keefe probe that's now confirmed as closed. ARCA got paid like $9,000 and $26,000 was de-obligated, or $25,000 or so. And then because Read withheld that, now there's another Rule 14 violation that Read's been hit with, and ARCA can testify, but they have to be subject to another voir dire before they can testify. And in this response to the state's request for more reciprocal discovery, we get admissions from Read that that Read's team paid ARCA. The only funds paid to ARCA to date is $27,606.41, detailed on the invoice, which wasn't provided to the Commonwealth until 2/13/2025. Read's team tried to hide it. And then now we learn that defense has retained ARCA for again, but this time, notice, different than the first trial, they actually disclosed the retainer to the Commonwealth, which means ARCA can be crossed on it. And then there's also another admission in here that there was like a TUI request sent to the U.S. attorney by Read's team in February, and then things with that. And then also this request talks about how David Yannetti got a subpoena back in 2022. And Yannetti tries to say something about it's ongoing. No, protective orders and subpoenas don't end when an investigation ends. They just keep going. So people were totally wrong about the timeline there. It doesn't mean there's an ongoing federal probe in any way whatsoever. All right. We have been going for 4 hours and 15 minutes. I'm still, I don't even know how this is possible. I think the upper range of the human larynx is like 3 hours. I don't know how you get me to talk for 4 hours. I don't know how I have 4 hours worth of things to say. It blows my mind. I just don't understand. But I guess you all find it useful. I'm so glad you all had a good day. I had a great morning with you. I truly do feel that the way in which we all engage here is so pleasant, and I think all of the friends that join on, towels, washcloths, and otherwise, make me a very happy towel, and I feel like I'm fulfilling my vocation on the earth and serving as a conduit, and in turn being able to convey information of the highest order that really benefits the public at large, and there's nothing that makes me feel more fulfilled. It's sad that I have to relay this information in the context of devastatingly sad, just overwhelmingly sad circumstances as to John O'Keefe's death, in my opinion, at the hands of Karen Read. But at the same time, if I can do honor, if I can do justice and honor, I think the legacy and the principles and the life that John was reflecting in adopting his double orphan niece and nephew, or any number of acts of service that he was doing, serving as a police officer in a very difficult branch of law enforcement, then I'm just doing my part. And my wider role as a towel and trying to encourage people about the virtue of unconditional love is just a benefit of being able to use my voice in this case for the purposes of spreading truth. And that's what I'll leave you with today. If there's anything you do today, I really hope it's that you take an opportunity to embrace or express love in some form. We talk a lot about politics in this stream, which from a realist perspective is all about demonstrating, expanding, and preserving one's power. Let's flip that around. Let's demonstrate, preserve, and expand our capacity to demonstrate unconditional love for one another. And maybe as a thank you to Towel for doing his work today, you can go out there and do something nice for other people, one act or multiple acts of service today, and that would make Towel very, very happy, and you can tell me about them when we see each other next. And yeah, that's the way to pay it forward, I think. Continue to demonstrate the fact that love, even though it's disadvantaged in its battle against hate, is persistent because it comes from an authentic place, and the easiest way to come across authentic and do things without notes like this is to simply be authentic. And I am authentic in my love for you all and my appreciation for you watching. Have a great rest of your Saturday. It means so much that I got to see you all. And everybody enjoy your day and give your towels and washcloths some extra love. All right. God bless. See you very soon. I appreciate all your time. My name's GrantSmithEllis. Thanks for being with me.